We are on the record for the hearings and the matters listed in the North Dakota Industrial Commission hearing docket for June 11th. I am David Garner, hearing examiner for these hearings. We are at the hearing room for the Department of Mineral Resources Oil and Gas Division, and it is 9 a.m. There are 12 cases on the docket, which will be consolidated into one hearing. Before calling them, I would just like to give anyone appearing an opportunity to discuss any housekeeping matters or anything that we need to discuss at this point in time.
I'll make an appearance, Mr. Examiner, if that's appropriate. Lawrence Bender, P.O. Box 1855, Bismarck. I'm with Frederickson Law Firm, and with me here today is Mr. Ty Glutt. He's immediately to my left.
Derek Broughton with Broughton Law Firm, Bismarck, North Dakota, here appearing on behalf of and representing a number of the landowner interveners, including the Swenson Living Trust, Michael Bauman, Glenn and Lisa Gerbing, Michael and Bonnie Haupt, John Yoakum, Kevin and Kimberly Kraft, Charmaine Liebelt, Kirk and Linda Mays and Alan Mays, Paul and Christy Metz, Jolene Rust, and Gary and Cassie Smith.
Okay, and before I call the cases, I would just like to note, in the interest of time, please try and have the witnesses not repeat each other's testimony. It would obviously make things go a lot quicker if we can just keep it to that. And that, just as a reminder, this is not a PSC hearing on the pipeline. This is a Industrial Commission hearing on storage facilities. So please keep your testimony limited to that subject matter.
Mr. Examiner, maybe now is the appropriate time, since you mentioned you're consolidating the cases, and we believe that is going to be very helpful in expediting the hearings here today. You may recall in some of the other CO2 sequestration matters we've had before the Commission, we've called our witnesses in groups. Those groups are typically no larger than two, but I think that also expedites the hearing process, because you can have two individuals up. One individual may not know the answer to something, the other witness is there, and that has in the past worked pretty well instead of calling them singly in terms of expediting the hearing process. And I did talk to Mr. Broughton about that before the hearing.
And one other matter, there was a motion to compel submitted at 5 p.m. last night. Attorney Bender, did you have an opportunity to review that motion?
I did not.
You did not?
But I will respond to it in, I don't know what the time period is, 10 days or 14 days, but I will respond to it, probably even respond to it more quickly than that.
Okay. Well, with that, I will call the cases. Case number 30869, in the matter of a hearing called on a motion of the Commission to consider the application of Summit Carbon Storage No. 1 LLC, requesting consideration for the geologic storage of carbon dioxide in the Broom Creek Formation from the Madison Carbon Express Pipeline. Case number 30870, in the matter of a hearing called on a motion of the Commission to consider the application of Summit Carbon Storage No. 1 LLC to consider the amalgamation of the storage reservoir pore space, in which the Commission may require the pore space owned by the non-consenting owners be included in the geologic storage. In the matter of a hearing called on a motion of the Commission to consider the application of Summit Carbon Storage No. 1 LLC for an order of the Commission determining the amount of financial responsibility for the geologic storage of carbon dioxide from the Midwest Carbon Express Pipeline. Case number 30872, in the matter of a hearing called on a motion of the Commission to consider establishing the field and pool limits for lands located in sections 31, 32, 33, and 34, Township 142 North, Range 87 West, sections 1, 11, 12, 13, 14, 15, 22, 23, 24, 25, 26, 35, and 36, Township 141 North, Range 88 West, sections 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, and 35, Township 141 North, Range 87 West, sections 1, 2, 3, and 12, Township 140 North, Range 88 West, and sections 4, 5, 6, and 7, Township 140 North, Range 87 West, Mercer, Morton, and Oliver County, subject to the application of the Summit Carbon Storage No. 1 LLC for the geologic storage of carbon dioxide in the Broom Creek Formation. Case number 30873, in the matter of a hearing called on a motion of the Commission to consider the application of Summit Carbon Storage No. 2 LLC, requesting consideration for the geologic storage of carbon dioxide in the Broom Creek Formation from the Midwest Carbon Express Pipeline. Case number 30874, in the matter of a hearing called on a motion of the Commission to consider the application of Summit Carbon Storage Number 2, LLC, to consider the amalgamation of the storage reservoir pore space, in which the Commission may require that the pore space owned by the non-consenting owners be included in the geologic storage as required to operate the Summit Carbon Storage Number 2 LLC storage facility. Case number 30875, in the matter of a hearing called on a motion of the Commission to consider the application of Summit Carbon Storage Number 2 LLC for an order of the Commission determining the amount of financial responsibility for the geologic storage of carbon dioxide from the Midwest Carbon Express Pipeline. Case number 30876, in the matter of a hearing called on a motion of the Commission to consider establishing the field and pool limits for lands located in sections 27, 28, 29, 32, 33, 34, and 35, Township 143 North, Range 88 West, sections 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 32, 33, 34, 35, and 36. Township 142 North, Range 38 West, 88 West. Sections 5, 6, 7, 8, 17, 18, 19, 20, 29, 30, and 31. Township 142 North, Range 87 West. Sections 1, 2, 3. Township 141 North, Range 88 West, Mercer and Oliver Counties, North Dakota, subject to the application of Summit Carbon Storage Number 2 for the geologic storage of carbon dioxide in the Broom Creek Formation. Case number 30877, in the matter of a hearing called on a motion of the Commission to consider the application of Summit Carbon Storage Number 3 LLC, requesting consideration for the geologic storage of carbon dioxide in the Broom Creek Formation from the Midwest Carbon Express Pipeline. Case number 30878, in the matter of a hearing called on a motion of the Commission to consider the application of the Summit Carbon Storage Number 3 LLC to consider the amalgamation of the storage reservoir pore space, in which the Commission may require that the pore space owned by the non-consenting owners be included in the geologic storage as required to operate Summit Carbon Storage Number 3 LLC storage facility. Case number 30879, in the matter of a hearing called on a motion of the Commission to consider the application of Summit Carbon Storage Number 3 LLC for an order of the Commission determining the amount of financial responsibility for the geologic storage of carbon dioxide from the Midwest Carbon Express Pipeline. And 30880, in the matter of a hearing called on a motion of the Commission to consider establishing the field and pool limits for lands located in sections 36, Township 143 North, Range 87 West, sections 19, 20, 21, 28, 29, 30, 31, 32, 33, 34, 35, and 36, Township 143 North, Range 86 West, sections 1, 2, 11, 12, 13, 14, and 24, Township 142 North, Range 87 West, sections 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 32, 33, and 34, and 35, Township 142 North, Range 86 West, and sections 6, 7, 17, 18, and 19, and 20, Township 142 North, Range 85 West, Oliver County, North Dakota, subject to the application of Summit Carbon Storage Number 3 LLC for the geologic storage of carbon dioxide in the Broom Creek Formation. All interested parties, please come forward.
Made my appearance.
You have-
Maybe one more housekeeping matter, Mr. Examiner. As you know, these applications are lengthy in the terms of how long it actually takes to get to the point where they be put on the docket. Numerous documents are filed with the Commission, both in paper and electronically, and those all become part of the record. What we've done here today is we want to focus on what we're going to refer to as the final form of application. And that's what we have done is we've provided a paper copy of that final form to Sarah as the official record. I know everyone has it on their computers, so we didn't make a bunch of copies. I think the last time or the time before, I made a bunch of copies and I took them back because no one wanted them. I did offer a copy, paper copy, to Mr. Broughton. He indicated that he was going to follow along on the computer. The witness will have a paper copy to follow through, and like I indicated, Sarah will have the official record. What our plan is today, Mr. Examiner, in addition to consolidating, what we're going to do is spend some time going through in relatively great detail the application for the Langang storage unit. And after we go through that in detail, there will be some testimony as to the to the other storage units, the Fisher and the Hints. But for the most part, we're going to go through very carefully the Langang application, and after we finish that, we will then call a witness who will summarize and compare the differences between Langang versus Fisher and Hints. We did that in the Minn Kota application, thought it worked pretty well, saved a lot of time, where hopefully we can do the same thing here.
Okay.
And with that in mind, we have two witnesses that we'd like to call, Wade Boeshans and Jeff Scari.
Can you repeat the first name?
Wade Boeshans, Boeshans,
And the next one again?
and Jeff Scari, Skaare.
Mr. Boeshans. Oh, they're coming in. I'm sorry.
Yep. Oh, sorry.
Please raise your right hand. Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Wade, would you state your full name for the record, please?
Wade Wayne Boeshans,
And by whom are you employed?
Summit Carbon Solutions,
In what capacity?
as Executive Vice President.
Wade, what I'd like you to do to begin with is briefly highlight for the examiner, the commission staff, and opposing counsel your educational background and work experience.
Sure. My education, I have a BS in Civil Engineering from North Dakota State University, as well as I've completed the Executive Leadership Program through the University of Minnesota's Carlson School of Business. My work background, after graduating, I started my career in consulting engineering, doing residential development in Phoenix, Arizona. Came back to North Dakota 2 years later and started my career in the lignite coal industry near Beulah. Worked around the country in Gulf Coast, Powder River Basin. Came back to North Dakota about 20 years ago, and most recently was the president and general manager of BNI Coal and BNI Energy, operating the mine up by Center, and as a subsidiary of Elite, a diversified energy company. While I was there, it became very apparent to me that for there to be a future in the lignite industry, we were going to need a carbon solution. And so I started investing a significant amount of my time and energy working with other industry leaders, research leaders, to advance the science, engineering, and regulatory frameworks for commercializing carbon capture and storage.
Okay, Wade, let's talk a little bit about some of your duties and responsibilities with respect to your employment with Summit Carbon Solutions.
Yeah, as Executive Vice President, I have responsibility for the CO2 sequestration scope of Summit's project. I lead a team based here in Bismarck that is responsible for, the engineering design, permitting, ultimately construction of the storage facilities.
Okay, now let's move into what you're primarily here to talk about today, and that's the project, and I'll refer to it as a project summary. Can you provide us with some background on Summit Carbon Solutions?
Yes. So Summit Carbon Solutions is a U.S. company with U.S. roots that is committed to driving economic growth and job growth in the Midwest, reducing emissions and providing a substantial boost to the agriculture and energy industries that are critical to rural American communities and the livelihoods of its citizens. We believe we can fulfill those commitments through carbon management solutions. And so in 2021, the company announced its partnership with ethanol plants to build out what is now known as the Midwest Carbon Express system. And in that partnership, what we're proposing to do is to capture CO2 that's currently being emitted into the atmosphere from those plants, transport it to North Dakota via a pipeline system, and inject it in the deep subsurface, approximately 1 mile below the surface, for injection and permanent storage and sequestration.
Okay, Wade, now I'd like you to turn your attention to exhibits 1A, 1B, and 1C. Can you tell me what those exhibits are?
Yeah, so Exhibit 1A is the application in final form for the Carbon Storage LLC number 1 TB Langang permit application.
And then what is exhibit 1B?
It is the application in final form for Summit Carbon Storage number 2 geologic storage facility permit for the BK Fisher.
And what is exhibit 1C?
It's the application in final form for the KJ Hence storage facility permit.
Move admission of these 3 exhibits.
Any objection?
Just a point of clarification, if I may. I should have asked this beforehand, but the exhibits that we're referring to here that you're submitting are the same as the applications on a case docket, right?
That's correct.
Okay, no. I object to any kind of hearsay within hearsay, unsupported statements that are contained within the applications, to the extent we're marking and admitting the applications just to have the application in the record. I don't have an objection to that.
Objection is noted. The exhibits are admitted.
Okay. What I'd like you to do, Wade, is let's turn to what's been previously marked as exhibit 2A, 2B, and 2C. And this is an exhibit we haven't handed out yet. We'll do that right now.
This is a different one. This is 2B.
Wade, can you briefly describe what these exhibits are?
So these exhibits, let's start with 2A, is a updated business structure that depicts, the SES number, LLC number 1 business structure as a wholly owned subsidiary of Summit Carbon Storage.
And were these 2 exhibits prepared either by you or under your control and supervision?
Yes.
For the exhibits.
Any objection?
No objection.
Exhibits are admitted.
Why don't you spend a little time, Wade, just going through exhibits 2B and 2C and explain just what is being requested.
Yeah, so the exhibit reflects the business structure, as I mentioned. At the bottom, you see the Summit Carbon Storage LLC number 1, Summit Carbon Storage LLC number 2, and Summit Carbon Storage LLC, which respectively are the owners and operators of the TB Langang storage facility, BK Fisher storage facility, and KJ Hence storage facilities. These are all wholly owned subsidiaries of Summit Carbon Storage LLC, which is a wholly owned subsidiary of Summit Carbon Solutions. Also, you see on the diagram SES Carbon Transport, which is the operator of the pipeline system and will be the operator of the flow line systems included in the 3 respective storage facility permit applications. We will have operating agreements between Summit Carbon Storage LLC number 1, number 2, and number 3, and Summit Carbon Transport, or SCS Carbon Transport, LLC.
Okay. All right, well, thank you for describing Exhibits 2B, 2C. Let's now, I'll ask you the question again. What are each of these applicants requesting?
They're each requesting commercial permits for operations, an injection of CO2, and the flexibility to receive CO2 from a variety of industrial sources.
Okay, now you've touched on this, but can you go into a little bit more detail in terms of the purpose of the application that are being made by SCS1, SCS2, and SCS3?
Yep. The purpose of the application is to receive, commercial permits to operate the TB Langang storage facility, the BK Fisher storage facility, and the KJ Hentz storage facility for the injection of CO2.
And where is the CO2 that these entities are planning to store? Where's that coming from?
The CO2 is coming from industrial sources across 5 states in the upper Midwest: North Dakota, South Dakota, Iowa, Nebraska, and Minnesota.
And I'd like you to now to maybe explain just in a little bit more detail the Midwest Carbon Express project.
Yeah, so the Midwest Carbon Express project is a integrated carbon capture, transportation, and storage project. It proposes to capture CO2 from industrial facilities across the 5-state footprint, transport that CO2 to North Dakota via a pipeline system where it will then be injected and permanently stored.
Okay, why don't you go into a little bit more detail in terms of after the CO2 is captured and it comes to North Dakota, what happens next?
So after the CO2 is captured, it's transported via a pipeline system. Essentially, we have smaller, what I describe as lateral lines connecting each one of the sources to a mainline trunk line system, 24-inch line that will deliver the CO2 to North Dakota, to the area of the storage facilities in Oliver and Mercer counties, where we would then inject the CO2 into the Broom Creek Formation per these applications for permanent storage.
Now, Mr. Garner made it pretty clear that today is not a PSC hearing, it's an industrial commission hearing, and we don't want to talk about pipelines, but I think it might be appropriate just for you to describe very, very briefly construction of the pipeline.
Yeah, so as I mentioned, it's an integrated pipeline system, about 2,500 miles. It will all be designed, constructed, and operated per PHMSA standards. Have a minimum depth of pipe of 4 feet to the top of pipe. All the pipe is high carbon or high strength carbon steel, and the system will be fitted with automatic valves and remote system operations, and operated through a control center based in Ames, Iowa, and be monitored and operated 24/7.
And what's the cost of the project?
It's about $8 billion.
And how does this project, what you're here today to discuss, compare to other CO2 sequestration projects?
So it's similar to the currently operating Red Trail Energy ethanol carbon capture project and the Blue Flint carbon capture ethanol project up at Underwood. Similar to those in that we're capturing, planning to capture CO2 primarily from ethanol plants and sequester it. The difference being that this project has 57 plants, so it's much larger in scale, and includes a longer transportation system.
And what does this project do in terms of benefits to the U.S. economy?
So the ethanol industry in the U.S. supports about 360,000 jobs and contributes about $45 billion annually to the U.S. GDP. Our project, which is proposing to connect with 57 ethanol plants Those 57 plants produce about 5.7 billion gallons of ethanol annually and consume about 1.7 billion bushels of corn that is produced on 30 million acres, or about 30 million acres. So significant to the regional economy and regional corn market. Additionally, we also have an agreement with a sustainable aviation's facility that's proposed in South Dakota. And sustainable aviation fuels are essentially making jet fuel out of corn. Last year, it was reported that 158 million gallons of sustainable aviation fuels were delivered to the airline industry globally. That same industry has commitments for 3.3 billion gallons by 2030. So that is a significant opportunity for the corn producers and by extension the corn markets, which has a material impact on land prices and commodity prices.
Wade, I now want to direct your attention to Exhibit 3A. I've had it circulated amongst the commission staff and opposing counsel. Can you tell me what Exhibit 3A is?
It's the project overview map.
Okay, and was this prepared by you or under your control and supervision?
It was.
Offer the exhibit.
Any objections? The exhibit submitted.
Let's take a look at Exhibit 3A. Wade, can you briefly discuss what's contained upon it and the importance of this exhibit with respect to this hearing?
Sure. So the exhibit is a project overview map. All of the red squares on the map are the approximate locations of the 57 ethanol plants that are part of the project. And then in the gray shaded area in North Dakota, you can see the diamonds that reflect the approximate location of the storage facilities that we're proposing to permit. The significance of this exhibit is that it revises the figure PS2 that's in the application and revises the number of plants to 57 sources.
So PS2 would be in each one of the exhibits, 1A, 1B, and 1C, is that correct?
Yes, that's correct.
And this would, in essence, be updated information to that particular page, is that correct?
That's correct.
Now, you spent some time discussing what this project will do for the U.S. economy. Can you tell us what it will do, what the project will do for the 57 ethanol plants that you just briefly mentioned and that are depicted on your Exhibit 3A?
Yes, so what the project does for the ethanol plants is it allows them to lower their carbon intensity score of the ethanol they produce, which then enables them to participate in emerging low-carbon fuels markets, both fuel transportation and potentially sustainable aviation fuels in the future. And by doing so, in essence, the biggest thing it does is it solves for the proximity challenge, if you will, in that, as you can see by the diagram on Exhibit 3A, most of the ethanol plants are situated over the Corn Belt, which the Corn Belt is not situated for most of the plants over suitable geologic storage. And so ultimately it provides a opportunity for these plants to capture their CO2, lower their their CI score, and transport their CO2 to a suitable geologic storage basin here in North Dakota.
Now I'd like you to spend just a little time explaining what benefits this project will bring to North Dakota.
Sure.
So I'm going to object, Your Honor, to the extent this is being offered as any kind of expert testimony without foundation about any kind of economic or other benefits that would require some sort of economist. If he's just talking generally about what they believe the benefits of the project are, I don't have that objection.
Overruled.
You can answer.
Yeah, so, the North Dakota economy, or agriculture and energy, represent about 70% of the North Dakota economy. And in North Dakota, we produce a significant volume of corn. The Red Trail, or excuse me, not the Red Trail, the Tharaldson ethanol plant, which is part of our project, consumes about 60 million bushels of corn a year. We grow between 350 and 400 million bushels of corn per year. So the Tharaldson plant alone consumes around 15%, 15 to 20% of the corn that's produced in North Dakota annually. Additionally, the ethanol industry consumes over half of North Dakota's corn. And so this project and its participants provide material markets and market demand for corn that's grown here in North Dakota.
Okay, and some of the CO2 that's going to go into your storage facilities that are before the commission today are going to be coming from the Tharaldson ethanol plant. Is that correct?
Yes.
And can you tell me where the Tharaldson ethanol plant gets its corn from?
According to my conversations with Tharaldson, they purchase corn from about a 150-mile radius around the Castleton plant there.
And how does the project, in your opinion, benefit agriculture and energy in the state of North Dakota?
It benefits agriculture and energy in North Dakota in that it develops CCS infrastructure, or specifically carbon pipeline infrastructure. That is a common carrier system that could be used for others. It commercially deploys CCS in the state that, again, provides support for others doing the same.
And in your opinion, is the project good for or benefit regional corn markets?
Yes, it provides significant demand for regional corn.
Let's talk a little bit about stream composition. And what I mean by that is what's the composition of the CO2 going to be? And perhaps we could turn to Exhibit 1A, and on page PS3. Might be easier for everyone to follow if we're looking at that page. Can you just briefly summarize what's contained on that page?
Yeah, so table PS1 on page PS3 indicates the CO2 system specification. As you can see, it's the system spec is greater than 98.25% CO2, and then trace amounts of other constituents listed in the table, primarily constituents of air, nitrogen, oxygen.
Okay, and you talked briefly about possibly down the road the project taking some CO2 from a sustained aviation fuel facility. What are some of the considerations that Summit will have with respect to the requirements for potentially taking this additional CO2 from non-ethanol sources?
Yeah, so we have conservatively designed the system within this permit to greater than 95% CO2. And so as we secure new sources, the requirements will be that they're greater than 95% CO2 at capture, and when commingled and delivered to the sequestration sites, greater than 98.25% CO2.
And Wade, is North Dakota a good place to store or sequester CO2, and if so, why?
Yes, North Dakota has ideal geology for sequestration. We'll hear a lot from the rest of the team here later about the geology, but specifically, North Dakota has extensive sand layers that are surrounded by confining layers that provide for that cover a large areal extent and provide for suitable geologic reservoir for storage.
Wade, you sometimes hear concerns that perhaps we shouldn't be storing CO2 in the state of North Dakota from other states because there is this concern about whether there's an abundance of storage space in North Dakota. Can you tell us a little bit about what your understanding is of that?
Object to foundation.
Overruled.
Yes, the U.S. Geologic Survey has reported an estimated storage resource in the Williston Basin of over 250 billion tons. That would be the equivalent of storing all of the CO2 from all North Dakota industrial sources for over 5,000 years. So it's a very prolific storage resource.
Okay, Wade, I'm going to direct your attention to exhibit, wait a minute. Not ready. Yeah, I'm going to direct your attention back to exhibit 1A, and particularly page PS5. Can you provide us with an overview of the proposed location? Sorry about that.
Sure, as you see laid out in figure PS3 on page PS5 of Exhibit 1, you see the locations of the storage facilities within Oliver and Mercer counties. And so you see that the BK Fisher site, or SCS number 2, SCS number 2 as the applicant, is located in Mercer County. And then SCS number 1, the TB Land Gang, is located in Oliver County, and SCS number 3, the KJ Hintz storage facility, is located in Oliver County as well.
Do you believe this is a good area to store CO2?
We do.
Object to foundation.
Overruled.
How did Summit select this project area and the injection sites?
So we looked at, available information, particularly mapping of Blue Creek sands thicknesses, previous oil and gas and stratigraphic well drilling information, ultimately identified an area in that included Oliver, Mercer, and Morton counties as a suitable target area for CO2 storage.
Okay, and talked about the storage area, but what about, how about the injection sites? How did you select those?
So after we'd identified, this general area of the 3 counties, we then identified a specific area within that based on that information of about 170,000 acres. We proceeded to secure permissions to do survey and secure land rights and completed site-specific characterization, including seismic survey on over 95% of roughly 140,000 acre block within that. Then based on utilizing kind of that information to build engage with the ERC to build a geologic model, run simulations, and based on the geology of the area, as well as landowner participation or cooperation, those who had signed leases, and then considering also surface infrastructure, including roads and availability of power and locations of dwellings, et cetera, identified the specific injection sites and the storage boundaries came from that.
Now, Wade, are there flow lines that are associated with the injection wells? And if it's easier to discuss that by looking at Exhibit 1A, please do so.
Sure. Yes, I'm looking at figure PS3 on page PS5 in Exhibit 1A. You can see that there are flow lines. You see the main line system on this diagram labeled NDM 106 comes into the to Oliver County. At that point, there's a terminus, and then there's flow lines from that point out with NDL 326 going to the KJ Hintz site, NDL 327 continuing to the west to the TB Lang site, and then NDL 325 going to the BK Fisher storage site.
And in selecting this area, did Summit give any consideration to other permitted projects in the area?
We did.
Okay, and perhaps I've already handed it out, but Exhibit 4A, show you what's been marked Exhibit 4A. Can you tell me what that exhibit is?
Yeah, so this is an exhibit that includes the 3 summit sites proposed in the application here, 3 summit storage facilities, TB Langang, BK Fisher, and KJ Hens, as well as the already permitted Minn Kota facilities, DCC West and DCC East. And what you see from that is kind of the proximity between the storage facilities, with DCC facilities being closest to the KJ Hens site. It's approximately 11 miles from the DCC West injection site to the KJ Hens injection site, and about 19 miles from the DCC East injection site to the KJ Hens injection site.
And it's, I'm sorry, interrupted you.
And the storage boundaries between DCC West and KJ Hens are approximately 3 miles apart.
And is it a fair statement that you're very familiar with both the permitted sites and the proposed sites that you're here today to permit?
I am.
And is it a fair statement that this exhibit was prepared under your control and supervision?
Yes.
Okay. Offer Exhibit 4A.
Any objections?
Yeah, I object to foundation.
Overruled, the exhibit is admitted.
Wade, you indicated that Summit did consider impacts on other permitted projects. Which permitted facilities did Summit consider?
The DCC West and DCC East permits.
Okay. And can you explain just a bit as to what sort of considerations you gave to those sites?
Yeah, so what you're seeing on the exhibit indicates the extent of the CO2 plumes of each of the 5 sites operating at permitted limits at the end of 5 years. And so as you can see, the plumes do not go outside of the storage areas by the end of 5 years, which of course is then our understanding that the commission requires a reevaluation and adjustments to the permit in a 5-year reevaluation period. And so what this tells us is that there is no risk from this simulation, indicates the plume boundaries are within the storage area at the end of 5 years and the renewal period, which then gives us the opportunity to validate modeling assumptions and adjust accordingly, or present to the commission proposed amendments to the permits.
And this shows what you believe will be the plume extent after 5 years, is that correct?
That's correct.
And you said the commission will have an opportunity to review the storage areas or the storage units after 5 years, is that correct?
That's correct.
Is it also your understanding that the commission has continuing jurisdiction, and if it deems necessary, could review earlier than 5 years?
Yes, that's correct.
Okay. Now, Wade, in the past, the commission has always requested information on an NAICS industrial classification code.
Yes.
Do you know what that is?
I do. It is NAICS code 486990, all other pipeline transportation.
Okay. And in your opinion, is the storage facility in the public interest?
Yes.
That's all the questions I have for this witness, Mr. Examiner. We would like to move to the next witness and then give the commission and opposing counsel an opportunity to ask questions at that time so they can switch back and forth without wasting time.
I'm sorry, you'd like to call your second witness before
Yes.
cross?
Yeah.
Any objections to that?
No.
Okay, we can proceed. Mr. Scar,
Yes.
Scari, sorry. Please raise your right hand. Do you solemnly swear or affirm under the penalties of perjury that the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Jeff, state your full name for the record, please.
Yeah. Jeffrey Scari,
And Jeff, by whom are you employed?
Summit Carbon Solutions.
In what capacity?
I am the Director of Land, Legal, and Regulatory Affairs for sequestration.
And what I'd like you to do next, Jeff, is, excuse me, I'd like you to briefly highlight for the commission staff and opposing counsel your educational background and work experience?
Sure. I received a Bachelor of Science degree in Business Administration from the University of North Dakota in 1997. Went on to law school at UND, received my Juris Doctorate degree in 2000. I have spent the majority of my career working in the oil and gas sector, primarily as a landman throughout mostly the Williston Basin.
Okay, and what are some of your duties and responsibilities with respect to your employment with Summit?
Yeah, my duties with respect to Summit include essentially the pore space acquisition efforts, which included mineral and surface title review, the document creation, the negotiations, and of course some of the surface facilities and flow line acquisitions throughout that project.
And you were also involved in the notice requirement that is provided by statute prior to holding this hearing, is that correct?
That is correct.
And would you characterize those notice requirements somewhat stringent?
They are.
Okay. Can you describe what you did in terms of identifying owners and then making sure those owners were provided notice?
Certainly. So we started by doing a complete surface and mineral title review of the areas inside the storage facility permits and within the 1/2 mile buffer outside of that particular area to determine who the record owners are.
And were you specifically involved in identifying those owners?
I was.
Okay, but you had others who were working under your control and supervision, is that correct?
That is correct. I oversaw the team.
Now, after you identified the individuals that you were going to provide notice to, what did you do next?
So consistent with North Dakota Century Code, we provided notice to all within that inside and 1/2 mile boundary, notice of the notice to all the surface owners, to all the mineral owners, to any mineral lessees within that same boundary, and any owner or lessee of record as well.
And was that notice given by certified mail return receipt requested?
It was.
Okay. And what information was contained in that notice, Jeff?
So, again, also consistent, we included the legal description of each of the storage facilities, the date, time, and location of the hearing, notice that a copy of the permit application was available through the NDIC. We also included an explanation on how comments could be submitted, and then lastly, notice that amalgamation would be required.
And you've indicated this was sent certified mail return receipt, is that correct?
That is correct.
And were all of the certified mailings delivered? In other words, did you get a green card back that was signed by the owner that you sent the certified mailing to?
We did not.
Okay. And what steps did you take with respect to giving notice to those individuals who did not receive notice, and you knew they didn't receive notice because the green card came back unsigned?
Yeah, when we received something back, we employed a third-party search to essentially identify an updated address. And when an updated address was obtained, we sent out a second notice.
Okay. Were you also involved, Jeff, in taking pore space leases, for the storage permit facility area?
I was.
And was all of that work done under your control and supervision?
Yes, it was.
Can you provide for us a brief summary of that?
Gladly. So the process started by identifying landowners through public court records, essentially verifying title, creating the documents necessary to engage with the landowners. Next, we did engage with those landowners and worked on any terms, and then we essentially moved forward acquiring a lot of that pore space through an option and a lease, and as a result signed approximately 90% of the landowners in the SCS1 TB Langang and approximately 92% of the landowners in the SCS number 2, also known as the BK Fisher. And then lastly in SCS, and when I say SCS, I mean Summit Carbon Solutions number 3, Storage number 3 LLC. In the KJ Hints, we acquired approximately 97%.
And having been involved in searching title to provide notice and searching title to take pore space leases, you would know if there was any federal acreage in any of these proposed units. Is that a fair statement?
That is a fair statement.
Is there any federal acreage in the proposed units?
There is not.
Are there any state acreage in the proposed units?
Yes, there is.
Okay, can you tell us a little bit about that? Where is it located and how much land are we talking about?
Within each of the applications, there is a single quarter of land that is under the control and direction of the North Dakota Trust Lands. The first one in the TB Langang, also Summit Carbon Storage number 1, would be in Township 141, Range 88, Section 36, in the southwest quarter. In SCS number 2, in the BK Fisher, there's 1 quarter in Township 143, Range 88, Section 32 in the southwest. And then lastly, in the KJ Hints, Township 143, Range 87, Section 36, the southwest quarter.
And has Summit secured an interest in the pore space of these state lands?
We have not.
Are you in the process of attempting to acquire a pore space lease?
We are actively engaged in our discussions with North Dakota Trust Lands.
Okay. Let's talk a little bit more about the fee owners. Can you very briefly discuss for us the procedure or procedures that Summit utilized under your control and supervision to secure pore space leases from private owners?
Sure. So once we have, as I testified before, determining title, we reached out both by phone calls and having landmen setting up meetings and meeting with specific landowners. Within the unit, one more sort of step that we took, I guess multiple steps, included after all of those engagements, when we had difficulty locating somebody, we did send out a copy of the option and pore space lease via certified mail. We did that last fall in 2023. We did the same again via certified mail to the unleased owners in just this past spring of 2024. In addition to that, we had sent out an invitation to, prior to the hearing, to all of the landowners, surface owners within the storage facility areas and within that half-mile buffer to essentially 2 different informational meetings. One was held in Beulah, and the second one was held in New Salem about a week apart to accommodate for schedules. And while we were there, we included a hard copy of the pore space, the option and pore space lease to be delivered directly. And then lastly, leading into these hearings this late spring, early summer, I personally took efforts wherein I was able to locate a phone number to contact the landowners that had not leased.
Okay. And with respect to those owners who have not leased at this point in time, are you requesting that the commission amalgamate those unleased interests? Is that correct?
That is correct.
And let's talk a little bit about, I think you testified that in TB Langang, you have approximately 90% of the pore space leased. Is that correct?
Just a touch under 90, yes, that
Okay.
is correct.
And what do you have with respect to the BK Fisher?
The BK Fisher is approximately 92%.
And the KJ Hints?
The KJ Hints is approximately 97%.
And do you know what the requirement is in terms of leased acreage within a storage area that you need before the commission can amalgamate the remaining portion?
I do.
What is that?
It is 60%.
Okay, and you touched on this when you discussed what you have been doing in terms of securing leases from private pore space owners. Now that you have those high percentages that you testified to, have you just stopped leasing? Have you taken the position, hey, this is, we're well over the 60%, we don't need to go out and get any more leases?
No.
Okay, what have you done?
We have continued to secure pore space leases. The last one, the most recent one signed yesterday morning.
All right, let me switch gears now on you, Jeff. Let's go to one of the exhibits, perhaps. That's Exhibit 1A, I believe. Is that
It is.
okay? And I'm going to have you turn in that particular Exhibit 1A to the storage agreement.
I am there.
Okay, and were you involved in drafting that storage agreement?
I was.
Okay. I'm going to have you go to Exhibit A in that storage agreement. It's a little confusing. We're in Exhibit 1A, but now we're going to go to Exhibit A of the storage agreement in 1A.
I am there.
And can you tell me what Exhibit A is?
Yes. It is a track map showing the boundary of the storage facility area. In that map, you can see the township ranges and sections. And in addition, you will be able to see the tract numbering system.
Okay, and you would have a similar storage agreement and a similar exhibit in each one of the other storage units that's before the commission today, the Hens and I guess that's the TB Langdang. You'd also have one for the Fisher and the Hens, is that correct?
That is correct.
Okay, let's go to Exhibit B. Tell me what Exhibit B is of the storage agreement.
Certainly. Track B, or excuse me, Exhibit B, rather, is the track summary of the different owners within that previous storage facility outline.
And can you describe the track participation for each pore space owner?
Certainly. What you will see across this document is, of course, the legal description, the total acres, the owners, the acreage that they own, which would then indicate their participation in the tract itself, as well as that tract's participation in the greater storage facility.
And since the application was filed, in fact, you mentioned a few moments ago that you've secured additional leases as recently as yesterday afternoon. Have you had an opportunity to update the tract participation summary, which is Exhibit B, in each one of the storage units in the 3 applications?
Yes, we have.
Okay. I'm going to show you what's been previously marked as Exhibit 5A. I'll just give it a minute till everybody has a copy. Okay, Jeff, let's turn to what's been previously marked as Exhibit 5A, 5B, and 5C. Can you tell me what each one of those exhibits is?
It is a tract participation summary, similar to what we just discussed as the track summary with the addition of the last column furthest to the right, showing the percentage of acreage leased with a total leasehold on the final page.
Okay, and let's just go to 5A. I don't think we need to go through each one of these, but let's go to the last page of 5A. You talked about it including an additional column. Does that confirm what you previously testified to, that Summit has approximately 90% of the area within that storage area leased?
That is correct.
Okay, and then that's how the other two exhibits would work as well, 5B and 5C, having that additional column and indicating what the percentage of leased acreage is.
That is correct.
Okay. Now for exhibits 5A, 5B, and 5C.
Any objection?
No objection.
Exhibits are admitted.
Let's go to Exhibit D in Exhibit 1A. We've been discussing Exhibit C, so that'd be the next exhibit, correct?
I believe we have not touched on Exhibit C.
Have not touched on what?
Exhibit C.
Okay. Well, we can, I think we did actually, but.
Okay.
So I think you testified that it was the track participation schedule, but to make sure, let's just go back very quickly to Exhibit C and tell me what that is.
Sure. Much like Exhibit B, it is a bit more of a summary showing the section of land that is, listed by tract with the acres of that particular section and the total tract participation. A bit more of a summary. Not to confuse everybody, I just wanted to
No, that's
make sure
fine.
we're talking about the same thing.
I thought we touched on it, but perhaps we did not. Let's go to D,
I am there.
okay? And tell us what Exhibit D is.
Yes, Exhibit D is the form of pore space lease that we used largely to acquire the percentages previously discussed.
Okay, and will non-consent, well, let me rephrase that. Will unleased owners be subject to the provisions of Exhibit D?
Yes.
Okay, and how does Summit propose to compensate the unleased pore space owners that appear in Exhibit D or ultimately do not lease?
Equally to the leased owners.
Okay, and can you be a little bit more specific in terms of what that means? Is there a bonus? Is there a royalty? Can you, and without giving percentages or numbers, because I think we've made some promises to landowners that we're not going to discuss that. So can you just generally talk about what's going to be the same?
Yes. So under the terms of the pore space lease, there is a bonus. That is the same bonus that we pay to the existing leased owners. So consistent with what you'll see in term or section 2A. In addition, we have a royalty that is called out, and that royalty is the same as well. That royalty can be found in paragraph 3 of the form pore space lease.
And it's based on tonnage of injection, is that correct?
That is correct.
Okay. Let's go to Article 8 of the storage agreement.
I am there.
Okay, and I believe it was your testimony that if the commission grants the request for amalgamation, this storage agreement will be effective for those owners, is that correct?
That is correct.
Tell me how unleased owners will be treated with respect to Article 8.
So consistent with our practices this far, we intend to specifically gauge with willing landowners and for any surface impact that may exist and try to minimize any impact that may exist on any surface owner. As it stands today, I do not believe we have any significant surface use needs outside of what we have leased.
Let me try to summarize that, and you tell me if this is correct. If you have unleased owners in a storage unit now, and the commission amalgamates those owners, you will do your level best, Summit will do its level best, not to have surface activities on those lands. Is that a fair statement?
That is a very fair statement.
Okay. What types of activities is Summit anticipating in terms of surface use within the storage areas?
As of today, we have identified our locations for injection. And
Let me stop you. I want you to talk about just generally first, and then you can talk about where you are in terms of the process. I apologize for interrupting you,
that's
Jeff.
okay.
But why don't you talk about just generally what type of surface use, and then talk about where you are in the process, the
Sure.
status.
Generally, for surface use, we would need, of course, our well site locations and the flow lines,
Perhaps some roads.
and perhaps some roads, yes.
Okay. Now let's move to where Summit is in that process.
Yes, thank you. So we have identified the location of our 3 injection wells, and we have worked with those landowners regarding those locations. We have secured 100% voluntary easements for the location of the flow lines, and we will continue to engage with the county as needed regarding any particular road use.
Okay, and with respect to well pads where you have secured surface rights, were those owners, did they also lease pore space?
They did.
Okay, and was that also the case where you have secured easements for flow lines?
That is true.
Okay. What was the approach that you took in securing surface for easements for well pads, flow lines, roads, that sort of thing?
Sure. We invited all the impacted landowners into our office in Bismarck, sat down with them and explained what we were doing and how it worked. We gave them all an opportunity to ask questions together. We met with some of them as a group and some of them individually, and came to terms and signed all of those easements.
Thank you, Jeff. I don't have any other questions at this time, Mr. Examiner.
Why don't we, rather than move to cross, why don't we take a 10-minute break at this point in time?
Okay. Did we discuss?
Okay, we are back on the record, and we will resume with cross-examination of the witnesses by Attorney Broughton.
Thank you, Your Honor. Why were the applications submitted by Summit Carbon Solutions LLC?
Excuse me?
Why were the applications submitted to the North Dakota Industrial Commission by Summit Carbon Solutions LLC?
So Summit Carbon Solutions LLC is the parent to Summit Permanent Carbon Storage, and the parent who is in the parent to or owner of Summit Carbon LLC number 1, 2, and 3.
And so Summit Carbon Solutions submitted the 3 applications on behalf of the Summit Carbon Storage number 1 LLC, Summit Carbon Storage number 2 LLC, and Summit Carbon Storage number 3 LLC.
I believe the applicant is Summit Carbon Storage number 1 LLC, number 2 LLC, and number 3 LLC. Correct.
So why did the applications get submitted by Summit Carbon Solutions LLC?
What do you mean by submitted? I'm not trying to argue with you, but
Filed with the NDIC?
Just that they were, Summit Carbon Solutions is the parent to Summit Carbon Storage, or excuse me, yeah, Summit Carbon Storage LLC 1, 2, and 3.
Okay. You talked a little bit about industrial sources for the CO2 coming into state, and there was discussion of ethanol plants and aviation facility. Is there anything else that is connecting, or are there any other sources connecting to the system that you didn't discuss?
Not at this time.
Okay. Do you have any plans to connect other sources to the system at this time?
We've had commercial discussions with others, but no affirmative plans, if you will, or agreements.
Are those discussions all with facilities that would have a CO2 stream within the parameters you set in your application?
So I'm not the chief commercial officer, so I can't speak to the specifics of the CO2 stream characteristics of all potential sources that we've had commercial discussions with. But per the application, they would be required to be within that specification.
Okay. Would you agree with the statement that North Dakota has a huge economic advantage because our geology is such that we can do storage and pore space in North Dakota where other states can't?
I can't testify to the, call it magnitude of advantage, but I would agree that being located on top of suitable storage is an advantage.
And so would you agree that Red Trail Energy as an ethanol plant has an economic advantage by being able to sequester its own CO2 emissions directly beneath the earth under its facility?
Yeah, again, I can't testify to the specific economics of Red Trail Energy and what their operating production costs are, et cetera, but certainly being located on top of geologic storage is advantageous to them, I would believe.
Does your project sell that advantage to ethanol plants in other states?
Can you restate that?
Does your project sell that advantage to ethanol plants in other states?
I don't believe so.
Do they obtain an advantage by being able to inject their CO2?
being able to connect to our system and by extension, store their CO2, they're able to lower their CI score. Yes, and then that creates an advantage for them or a benefit to them. I would,
And that takes away the advantage North Dakota ethanol plants would have if they were the only ones doing sequestration of their CO2.
I don't believe so.
How is that?
Well, I don't believe that the North Dakota plants can support, given their size, can support a greater than 1 billion gallon market.
So they would find themselves in a system, in a market with a massive demand and a low supply?
I would say that there likely wouldn't be enough supply to support the market.
Do you think that that supply could then be filled by development of other projects?
Potentially.
Do you think that other projects would have an advantage if they were able to sequester CO2 directly underneath their facility?
They may have.
All of the ethanol plants connected to your system but one are from outside of North Dakota?
Currently, yes.
You testified regarding what has been marked as Exhibit 4A. Do you have a copy of that in front of you still?
I do.
You indicated that this was prepared under your direction and control.
Correct.
Who prepared it?
The Energy Environmental Research Center.
And who at the Energy and Environmental Research Center prepared it?
I don't know specifically who.
How did you direct them if you don't know who they are?
I directed the project lead at the ERC to prepare this exhibit, but I don't know exactly which one of the ERC experts did the work.
Who is the project lead at EERC?
That would be Amanda.
Amanda who?
Amanda Douglas.
How long has Amanda Douglas been working on the project?
She's been involved in the project since we started developing the project in late 2021.
How did Amanda's team determine where to put the lines on this particular map for this exhibit?
Amanda will have to testify to that.
Well, you directed her to create this exhibit for you, right?
I did, correct.
What did you ask her to put on the exhibit?
I asked her to put on the exhibit the plume extents after 5 years of injection and the storage boundaries, et cetera.
Okay. Do you have an understanding of how the plume extent at 5 years was calculated and then put onto this map as a line?
Say that one more time.
I think I can. Do you have an understanding of how the plume extent at 5 years was calculated and then put on this map as a line?
Yeah, it's It's my understanding that the plume extent was calculated using dynamic model simulation to determine the extent.
Would it be fair to say that you wouldn't have any independent information of your own as to where the line should be drawn to indicate the CO2 extent at 5 years of injection?
That I wouldn't have any
I'm not trying to be tricky, let me be basic here. You asked Amanda to put the lines on here, but you don't know how she created these lines or where the data comes from to determine that that's where the line should go. So let me ask a better question now, that wasn't fair. That's just what I'm trying to get at, though.
Okay.
So, as far as where the plume extent is on this exhibit, you would have to rely on Amanda in order to determine whether that's accurate. Is that fair?
That's correct. I would have to rely on, the geoscience team and reservoir engineers at ERC that ran the model to produce the plume extent.
Okay. And so other than what you testified to that this exhibit 4A represents, in order to understand where all the information came from and how the decisions were made as to where to put the lines, we would have to talk to ERC about the models they ran.
Just to understand the process, if you will, and the modeling that produces the lines, the ERC geoscience team would be the experts.
Does Summit Carbon Solutions LLC have a contract with the EERC for that work?
It does.
And does the EERC have a contract with any of the Summit or SCS entities listed on exhibits 2A, 2B, or 2C other than Summit Carbon Solutions LLC?
I don't believe so.
To your knowledge, does EERC have a contract? Well, let me back up. Are you aware of any contracts EERC has with private parties that relate specifically to the project that we are here today for?
Specific parties related, can you specify which parties? Or
With anyone, but do you know if EERC has contracts with any private parties other than the one you just mentioned with Summit Carbon Solutions that relate to this subject matter and this Summit project that brings us here today?
I'm aware that they also have contracts with Minn Kota, but it's not related to this project.
Okay, yeah, so no, just related to this project, are you aware of ERC having contracts with other parties other than Summit for the purposes of working on or related to this Summit project?
I'm not.
Is the EERC a state-funded institution?
I'm not sure how the ERC is funded. I know they're part of the University of North Dakota, but in terms of how they're funded, I'm not aware.
Do they regularly take on work producing applications for industry clients to get permits for new projects?
Yes, that's my understanding.
What other projects are you aware of them doing that for?
I'm aware of them doing that for the Minn Kota projects, the DCC projects. I'm also aware that they did work on the Red Trail project.
So outside of the few carbon sequestration projects that have occurred in North Dakota in the last 5 or so years, Are you aware of EERC ever helping industry participants with applications to get permits for new projects?
I'm not aware of their role in projects, outside of North Dakota for sure.
But are you aware of them contracting with and helping industry participants with applications for permits for new projects outside of carbon sequestration?
I'm not.
Okay. Does the contract signed between Summit Carbon Solutions LLC and EERC in 2021 cover the scope of all work that EERC has done for Summit on this project?
No, we have multiple contracts with the ERC.
Okay. How many contracts does Summit or its affiliates and subsidiaries have with the EERC related to the project we're here for today?
Today we have, I believe, one active contract.
Okay. How many contracts have you had since you signed? And when I say you, I'm referring to Summit Carbon Solutions, LLC, its affiliates and subsidiaries. How many contracts have you had since you signed the first contract with EERC for this project?
I believe we had 4 separate.
And did the 4 contracts cover different subject matter or scope of work, or were they renewals of the same contract?
It was all similar subject matter, slightly different scopes.
Did Summit Carbon Solutions LLC or its affiliates or subsidiaries get bids or proposals from any institutions or consulting firms other than EERC for the work it eventually contracted to EERC?
Not that I'm aware of.
How do you know whether the expense or charges from EERC are competitive with other providers?
Objection, relevance. Overruled.
I would just say from the Summit perspective, we've engaged lots of different advisors across the broad scale of our scope. And so what we do is we look at rates comparable to what others would do for similar types of work on other scopes of the overall project. And that's how we judge competitive or not. But
Right, but you just said that with respect to the work EERC did for you, you didn't actually get any bids or scope out any other competitors to do that work, right?
we did.
You did?
No, excuse me, we didn't. We
You
did
did
not.
not,
Yeah,
okay.
that's what I said.
So how do you know if EERC's rates were competitive?
Again, as I stated, we look at similar proposals for similar types of work, permitting, engineering, modeling, those kinds of things on the project overall, and that's our best comparison.
So did you compare the work you were asking EERC to do with estimates or proposals from other institutions or consulting firms who could have done the work?
So if your question is, did we competitively bid the specific work? The answer would be, no, we did not get proposals for the exact scope of work or request for proposal.
Okay. Are you testifying that you did nonetheless generally look at rates for similar types of work as part of that process, or did you just choose to go with the EERC regardless of whether their rates were competitive?
We, again, looked at comparables to others to do, professional work in the same, not the exact same type of work, but what I would describe as similar work, and we accepted their proposal.
Is the amount charged by EERC more or less than what you saw in the similar types of rates that would be charged for work by other firms?
I don't recall specifically. I would say it was similar in nature from a, looking at hourly rates perspective.
Does Summit actually compensate EERC under the contract for their work they're doing?
If your question is, do we pay them for their services? Yes.
Are you familiar with the contracts Summit has with private engineering and consulting firms?
Generally,
Are there any provisions in the EERC contracts that allow them to do things like use your data for research and education purposes?
I don't recall specifically. I don't recall those provisions.
Do you have copies of those contracts?
We do.
Is there anyone testifying today that knows the provisions of those agreements?
Not that I'm aware of. It's possible, but I can't say for sure.
Does your contract with EERC require them to maintain your data in a confidential manner?
It does.
How does that work with a public institution subject to open record requests?
That would,
If you know, Wade.
yeah, I don't know for sure, but again, that's a better question for the EERC.
Are you having the EERC testify in support of your application?
We are.
You made some comments about the NACE industrial classification code. Can you tell me again what you were saying about that?
I was saying that this is the classification code.
According to whom?
That's it.
According to whom?
According to how it's been, I guess, classified based on the type of the system it is.
By whom?
Yes.
Yeah, I don't recall, what was the acronym again? Can you What was the acronym for the code? I think we have it somewhere.
NAICS Industrial Classification Code.
I don't have the answer for you, I'm sorry.
486990 was the number you guys gave. You knew that much, right?
We did.
What's that number for?
Not sure I'm the appropriate person to answer that question. We can,
Who knew? Well, let me ask the question again. What is the NAICS Industrial Classification Code you claim applies to the storage facilities?
I can't answer that question.
But you did.
No, I stated this is what the classification code is. We'll have,
But you don't know if it is?
I can confirm that Jay Volk, who will be testifying here later today, who works under my direction, made that determination along with our counsel, and he can testify specifically to that question.
What's his name?
Jay?
Jay. Did he make the determination that 486990 is the NAICS Industrial Classification Code?
Yes, that's my understanding.
Do you have any understanding of why?
I do not.
Is it because that refers, well, how would you describe the facility that you're saying has classification code 486990? What is it?
How would I describe the facility?
Yeah.
It's a storage facility.
Is it a coal pipeline transportation facility?
No, it's not a coal pipeline. I believe it falls in the other category.
Is it a slurry pipeline transportation?
It is not.
Is it pipeline transportation except crude oil, natural gas, refined petroleum products?
Say that one more time.
Pipeline transportation except crude oil, natural gas, refined petroleum products?
That sounds correct.
Your storage facility is for pipeline transportation?
Mr. Examiner, we can continue to waste time asking these questions. We've identified another person who may be able to help us with this, so.
He testified to this already, and only upon cross-exam is it being discovered that he doesn't know that much about it, but I think I'm entitled to exhaust my questions, given that this was a very specific code that they brought up on direct and said is the code, and I'm just asking why it is.
Overruled.
So you think pipeline transportation except crude oil, natural gas, and refined petroleum products is an accurate description of your carbon sequestration facility?
Yes, that's my understanding, based on the advice of our team.
Are you going to store the CO2 in a pipeline underground?
We're not. We're going to transport it to the site.
And then you're going to transport it out of a pipeline and into a wellbore, right?
Yes, it will. From the pipeline, it goes, to the wellhead, and then into a wellbore.
And then into the reservoir.
Correct.
Where's the pipeline? In the reservoir.
There is no pipeline in the reservoir.
Then why would you call a storage facility in the reservoir a pipeline?
Based on the, again, advice of our team, we believe that's the appropriate classification.
Well, but not because it's an accurate description of the facility, right?
It describes it as all other,
What describes what is all other?
the classification, as I understand it.
486990 is for all other?
Yes. That's my understanding.
There was some discussion earlier about how there are PSC hearings going on regarding the Midwest Carbon Express. Do you recall that?
I do.
Is the Midwest Carbon Express the same as the storage facility that we're here talking about today?
It's not the same.
It's a different project, right?
Well, no, the Midwest Carbon Express, excuse me. Wait, restate that. The Midwest Carbon Express is the pipeline. This is the storage facility that's part of the storage component of the Midwest Carbon Express project, if you will.
What is the Midwest Carbon Express project?
So the Midwest Carbon Express project, as I understand it, is the combination of capturing CO2 at the plants, transporting the CO2 via the pipeline, and storing the CO2 at the injection facilities that we're permitting here today, or the storage facilities, excuse me, that we're permitting here today.
Where does the Midwest Carbon Express pipeline end?
You said, where does the Midwest Carbon Express pipeline end?
Yes.
Yeah, it's, back to the exhibit that shows the terminus of the pipeline.
Can you direct me to the, or you're on one of the marked exhibits?
Yes. Oh, excuse me, it's in Exhibit 1.
1A.
Exhibit 1A. Page. Yes, if you refer to page PS5, figure PS3, the red box indicates the terminus of the Midwest Carbon Express pipeline. That's the end of the line.
With respect to the applications under consideration today, does the subject matter for those applications all begin where that pipeline ends?
It does.
And so when we're talking about an industrial classification that's applicable to these three sequestration facilities that we see on PS5, it would not be accurate to classify those as a pipeline, would it?
I don't agree with that. There's a flow line and the injection facilities that are all part of this application.
So the flow lines, anything else that you would consider a pipeline
Is this?
that begins after the terminus of the Midwest Carbon Express pipeline?
Anything else that I would consider a pipeline?
Right.
No.
Going back to Exhibit 1, PS5, the diagram you noted, there's a terminus point for the Midwest Carbon Express pipeline.
Yes.
Are there any booster pumping stations after that terminus point?
There are
Where are those?
at the well pads.
Okay. Is there a valve station at the terminus point?
Yes, there is.
Where is that valve station operated from?
All the valves will have the ability to be operated from the main control center and/or backup control center. Current plans for the main control center are in Ames, Iowa. They're also capable of being operated manually in the field.
You'd indicated there was no federal acreage within the sequestration areas. Was that a criteria used in the search in order to avoid federal acreage?
It was not.
Okay. You'd indicated you signed pore space leases yesterday. Was that with individual landowners?
It was.
You're asking the commission after this hearing to amalgamate all unleased property owners, is that right?
That is right.
If you've not reached a deal with the North Dakota Department of Trust Lands for the state-owned lands, are you asking the commission to also amalgamate the state-owned lands administered by the Department of Trust Lands?
So well, I can answer that question this way. Zach Pelham, who has been busy with a number of different hearings, has been appointed to assist the North Dakota Department of Trust Lands. We have agreed on the substantive lease or easement agreement, and we're anticipating the ability to complete that shortly. It just wasn't capable of being done prior to this hearing.
Have you come to an agreement on compensation?
I would say we've covered all substantive issues, including compensation.
What do you mean by you've covered the issue of compensation?
Sure. So, the state of North Dakota Trust Lands, of course, is a easement agreement for pore space rather than a pore space lease. We have presented and worked through a number of terms, including our compensation offers that are consistent with the existing leased landowners, and have received no pushback regarding those terms. We're working through the remaining terms on that agreement. Quite honestly, we've been very busy. We submitted this to the state, I would say probably about a year ago, and have been working on it off and on through that time frame.
Are the provisions of the easement that you're negotiating with the Department of Trust Lands different than the pore space leases you signed with landowners?
To the extent that they call it an easement versus a lease, yes. Beyond that, not any significant changes.
But there are some changes?
Sure, because they consider the pore space instead of a lease, they consider it an easement. But beyond those that is your primary difference, that they consider it an easement rather than a lease. So that would be a difference.
Are there any additional protections for reclamation or soils or anything like that in the Department of Trust land lease or easement?
Yeah, there are. However, as part of our discussions with the state, we have no plans for any surface on there. So again, those are, I mean, that's a good point. And I do believe that they have some specific requirements when there are pipelines or there are facilities. We, however, do not have any surface plans on any of those lands.
So why wouldn't you offer those same reclamation provisions to all of the landowners for whom you don't have plans for their surface?
Sure. In fact, we went further and offered every unleased landowner a no surface facilities clause, thus signaling that prior to essentially any surface encounter, that we would enter into a separate written agreement. So as we go forward with amalgamation, that was, if you recall in my testimony, that every unleased owner received a copy of the lease at the option and lease agreement via certified mail in the fall of 23 and again in the spring of 24 that included a no surface facilities clause.
Did you also include language related to soil reclamation and soil separation in the Department of Trust lands easement?
So they have what I would consider a standardized form regarding pipelines. In my experience of acquiring right-of-way in North Dakota, I've encountered that same form. That includes, of course, things such as, and forgive me, I'm going from memory, soil segregations, and other certain conditions, seed mixtures, and the likes. And I believe that they included that on this particular agreement. I know that Attorney Pelham and I talked about the necessity as we considered perhaps a no surface occupancy that would sort of negate the need for that, but it is on that agreement.
So you said you're familiar with some of the Department of Trust lands standardized forms. Would that be accurate?
I would say I'm generally familiar. I've been involved in other right-of-way.
So you're aware, for example, that the State Department of Trust lands has standardized forms for things like a pipeline easement or a well pad agreement out in the oil patch?
I am.
And you may also know that with some of those forms, they have some specific exhibits or attachments that cover things like their preferred seed mixture or soil stripping requirements. Have you seen those before?
I certainly have, yes.
And have you noticed that a lot of the language throughout some of those different agreements tends to be the same?
I would say it's a fair statement.
It was a bad question, but thank you. Are you aware of who at the Department of Trust lands actually drafts those agreements and forms?
I am not.
But we can assume it's the staff, right?
Yes.
Do you know who did a lot of, if not all of the negotiating for the surface division and the development, a lot of the surface divisions forms for the Department of Trust lands throughout the oil boom?
I would be speculating if I answered. I do not.
Do you know who Mike Haupt is?
I do.
Are you aware that he developed the forms and the leases that were submitted to Summit on behalf of landowners, working off of the exact same forms that he developed for the State Department of Trust Lands while he was at the state for his whole career?
Will you please repeat that?
Question, are you aware that he developed the forms and the leases that were submitted to Summit on behalf of landowners working off of the exact same forms that he developed for the State Department of Trust Lands while he was at the state for his whole career?
Okay. So what I want to answer your question, but are you specifically referencing a lease that we received?
Correct.
And what lease are we talking about specifically?
The one from Mike Haupt.
We received one from the Swenson Group that had some of the same forms that I would say looked familiar or similar to the state. I'm not sure that answers your question, but I understand that there was some similarities.
So does the state get that language in their contract and the landowners don't simply because they're the state?
I would disagree. We offered all unleased landowners a no surface occupancy.
But not protections for the surface, right?
Well, by entering into a separate written agreement in the event that we needed something, that would give them the opportunity. So we did not gain access to the surface for any facilities, pipelines, roads, or otherwise.
Until the end of this hearing, when you ask the commission to give that to you, right?
Under amalgamation, you are correct. Yes, there are certain rights that would come in that particular direction.
So it doesn't really matter what the landowner signed, does it?
What landowner? I'm sorry, I'm not trying to be tricky here. Can you ask?
Regardless of what any landowner signs with you for your project, they are going to be subject to Exhibit D to your storage agreement, right?
I would disagree,
Why?
because we have a separate written contract.
That is superseded by that storage agreement the second this commission issues its order, right?
No.
Okay. Why not?
Well, let me correct that. Your question was whether the storage agreement overrides the existing contracts with individual landowners for pore space leases. Did I understand your question correctly?
I don't know, but I'd like the answer to that question.
Sure. I believe that a written contract with our landowners is a contract that we will adhere to.
Unless it is in conflict with the storage agreement, right?
No.
So you're going to ask the Industrial Commission to impose the storage agreement and impose Exhibit D as a pore space lease on every unleased landowner, right?
Yes.
And are you saying that you're not going to impose that on the landowners that signed the lease?
It will exist, but I think there are additional protections in those leases, yes.
Additional protections that will not be superseded or obviated by the storage agreement?
Well, for example, where we have a no surface occupancy, we will honor that contract.
Okay, any others?
Nothing that comes to mind specifically.
So other than a no surface occupancy agreement, any agreement any landowner signed is not going to be honored if it violates the storage agreement.
I disagree with that. I think that is a mischaracterization of what I was trying to say.
Well, I'm not trying to characterize what you're trying to say. I'm asking you a question. If a landowner signed a lease with Summit for the use of their pore space, and that lease now has terms that conflict with the terms of the storage agreement, what controls?
We would honor the lease.
And so you're not asking the Industrial Commission to impose any kind of contractual terms on any single landowner if they signed a lease with you?
Okay, having an opportunity to re-review this, would you mind if I had the question read back to me so I can be accurate in my answer?
Question, and so you're not asking the industrial commission to impose any kind of contractual terms on any single landowner if they signed a lease with you?
I think we're asking them to execute the storage facility agreement as is here as part of the application. Not sure that it creates any additional burdens on landowners that we don't address in our lease.
Does the storage agreement or Exhibit D to the storage agreement have any applicability to a landowner who signed a lease with you?
It does.
How so?
I'm not sure I understand your question. Can you repeat it?
How does the storage agreement apply to a landowner who signed a lease, pore space lease with Summit?
Well, I believe the storage agreement applies to all landowners. However, I believe we've also entered into a separate legal contract or agreement with certain landowners that has additional details and considerations.
Does the storage agreement impose the lease at Exhibit D on landowners?
I would say it imposes those on the unleased landowners, yes.
Okay, and are you saying it does not impose Exhibit D in the terms of Exhibit D on the leased landowners?
I'd say that's a fair characterization. I believe that we've entered into a lease agreement with individual landowners.
Do the individual lease agreements that you've entered into with landowners have any material differences to the Exhibit D in the storage agreement?
I would say not material.
And that's because you absolutely refuse to negotiate any kind of material change to the lease for exactly that reason, right?
That is not true.
Well, why was it that you did not negotiate material changes to your lease?
Well, Mr. Broughton, through good faith negotiations with over 450 landowners, we acquired in excess of 146,500 acres, covering 16 townships and 3 counties. And from the start, we had some changes to that agreement.
How many?
Don't recall specifically, but we've made some changes to the agreement.
More than
Some,
5?
I don't recall the exact number.
Less than 10?
I don't recall the exact number.
Less than 20?
I don't recall the exact number of
Less
changes.
than 100?
I don't recall the exact number of changes.
But none of them were material.
No, I believe some were, including an increase in the royalty rate,
How much?
a 50% increase in royalty rate.
To whom?
All landowners that signed equally.
Okay. Okay, so you've made a few changes to the global lease you circulated. Other than changes that you made to the lease for anyone who signed the lease, did you make any changes to the lease in response to concerns expressed from any individual that were material?
Yes, as I testified before, as we developed the project, we offered a no surface facilities clause to a number of individuals.
Okay. Anything other than that?
Not that I recall.
How many leases did you say you signed?
So we've executed, the exact number I don't know. What I can tell you is I know that it's over 450 different individual signatures across multiple different agreements. That covers the large scope of the project, including the 146,000 acres that we've acquired.
And you didn't allow a single landowner, a single material change based on their concerns in all of those negotiations?
I think that's a mischaracterization.
Can you name one?
Sure, favored nations, at the request of your client.
And that went to everyone, right?
It did, yes.
So I'm talking about changes that weren't global to the lease for everybody who signed.
No, we treated everybody equally.
So no material changes to the lease form based on negotiations with landowners about their concerns.
No, but we took into consideration all of our discussions across that entire footprint with all these different landowners.
If your answer to the landowner's concerns and questions before they even express them is no, how is that good faith?
Well, our answer wasn't no. We sat down and had multiple meetings with many landowners from the start of the project.
How many material changes to the lease did those meetings result in?
Again, I don't know the exact number, but I can say that we've made some adjustments to that lease. I think that lease is reflected in the exhibits.
And so the landowners who signed a lease with you would get the same lease imposed on them if they had not signed that lease?
Yes, with a few minor exceptions. For example, a no surface occupancy clause that we granted to some.
Okay. Any other exceptions?
No.
Did you grant the no surface occupancy clause only to those landowners who you were not intending to put anything on anyway?
Well, I think the best way to understand this is that when we started our project and our leasing, it required some site characterization, and so we didn't have a complete understanding of where everything would go. Through that site characterization process, we were able to determine where those things are located, and so it is something that we were willing to grant to those once we understood where we were putting our facilities.
If you do not reach an agreement with the North Dakota Department of Trust Lands at the time that this commission issues its order, are you asking this commission to issue an order also amalgamating the state lands that are administered by DTL?
If we were unable to enter into an agreement and the commission entered an order, it would amalgamate those lands. It is not our intention to do that. As I stated previously, we've been actively working through the terms of that agreement with the attorney appointed to assist, who's been in some of the many hearings I think that you've been in too. So.
Has he shared any price points with you from other transactions?
Can you elaborate on that question?
Has the attorney that with whom you're negotiating for the Department of Trust Lands shared with you any price points or comparable transactions he thought you might want to review in talking about compensation?
They have not?
Lawrence, were you using, which number are you using for the application?
1A.
Okay. I'm going to have you take a look at Exhibit 1A, which I understand to be the application for the line gang facility.
Yes.
And I'd like to direct your attention to the storage agreement within the application. Do you have the page up in front of you? I show it as page 2 that has the recitals listed at the top.
I do.
Okay. So the recital states, it is in the public interest to promote the geologic storage of carbon dioxide in a manner which will benefit the state and the global environment by reducing greenhouse gas emissions, and in a manner which will help ensure the viability of the state's coal and power industries to the economic benefit of North Dakota and its citizens. How does the Summit project benefit the state and the global environment by reducing greenhouse gas emissions?
So clearly, our project reduces greenhouse gas emissions. We're storing significant amounts of CO2.
How is that a benefit to the global environment?
So it's reducing emissions, number one. Number two is we are providing, we are commercializing CCS and demonstrating commercial CCS that can be implemented for others or by others. We're also supporting North Dakota's largest industries. Obviously, the CO2 that's coming from our project is being originated from corn. And corn markets are important to the citizens of North Dakota, supporting commodity prices and land prices for our agricultural sector. We're also creating the opportunity for owners of pore space to monetize that value of that resource.
At whatever price you choose?
At the royalty rate in which we've agreed to with, in this case, 93% of their landowners.
You didn't change it for a single one of them though, right?
No, as Jeff testified to it, we adjusted the royalty rate during our negotiations.
Globally.
Correct. We entered into we included a favored nations clause, so it applies to all.
How does reducing greenhouse gas emissions benefit the state of North Dakota?
Well, in this case, it allows the plants, in this case, the ethanol plants to continue producing ethanol and selling that, having access to new markets, continuing the viability of those plants and that industry,
Which
and
ethanol
therefore
plants?
supporting therefore supporting the corn markets.
Oh, okay, sorry. I should have let you finish, sorry. But that's a benefit from a speculative uplift in the price of corn from the financial success of the ethanol plants flowing from their response to a regulatory issue, right?
I wouldn't characterize it that way.
How would you characterize it?
Corn is a globally traded commodity, and our project and our project partners create a significant demand. And so there's a supply-demand relationship. And to the extent that they continue to operate and purchase that volume and likely more, that has a positive impact on the overall agricultural commodity markets, and specifically corn.
Okay, so let's put that aside, and I want to ask my specific question again, which is how does reducing greenhouse gas emissions benefit the state of North Dakota?
Again, as I said, this project reduces greenhouse gas emissions.
But I'm not asking about projects that are benefits that flow from this project. I'm simply asking, how does reducing greenhouse gas emissions benefit the state of North Dakota? Or maybe I should start, does it benefit the state of North Dakota to reduce greenhouse gas emissions in Iowa?
So I think as you think about greenhouse gas, you can't think about it as one state at a time. Obviously, air goes everywhere. CO2 is in the air, so reducing it at one point impacts the overall concentration of CO2, globally, so to speak.
But that's not a substantial and direct impact for the citizens in North Dakota with respect to the air they're breathing because we took emissions out of the air in Iowa.
I would say that reducing, excuse me, reducing CO2 emissions, reducing CO2 emissions is not about making the air healthier. I don't really understand the question or the point of the question.
What benefits flow to anyone from reducing greenhouse gas emissions?
Yeah, go ahead.
Perhaps this will provide a little more understanding to the recitals. North Dakota Century Code, Chapter 382201 is policy. Reads, it is in the public interest to promote geologic storage of carbon dioxide. Doing so will benefit the state and the global environment by reducing greenhouse gas emissions. Consistent with the statute, we included this in our recitals, and we believe that there is benefits. I don't know that we can get into the very specifics here. I think you're asking a broad question.
What benefits do you think there are to the state of North Dakota from reducing greenhouse gas emissions? Can you name one?
Yes.
What?
I believe that it allows one of our major ethanol plants the opportunity to engage in low carbon fuel markets.
How does the Summit project help ensure the viability of the state's coal industry?
So I would say, based on my experience pursuing commercial CCS for the coal industry, the biggest challenge is others having done it before, haven't been done at large commercial scale. And so by deploying CCS at commercial scale, as we will here, we in essence build out the pathway, if you will, for others to follow and do the same. Additionally, we're building a CO2 transportation network that can provide benefits to others or opportunities for others to use as well.
So how is the coal industry going to benefit from what you're doing?
They're going to benefit from ultimately the demonstration at commercial scale and that it's been done, and that by extension makes the second of a kind, kind of provides a roadmap, so to speak.
Didn't Minn Kota already demonstrate it's fully capable of doing that and then come in here and express concerns about your application?
So Minn Kota has a proposed project that is yet to be constructed.
Have you constructed your project?
Not yet.
What projects are constructed?
Can you be more specific?
Well, Red Trail is demonstrating success with ethanol doing direct injection of carbon in North Dakota, right?
They are.
What are you doing that they don't already know how to do?
We are replicating the same or similar at scale.
You're just bigger.
Yes, it's bigger.
How does the Summit project help ensure the viability of the state's power industries?
In the same way.
If Summit constructs its project and injects CO2 as planned for the next 20 years, will that reduce the global temperature?
So you're asking me to speculate.
I don't know if I am.
You are asking me to speculate
Okay.
because I don't know what others are going to do as well.
Hold all other things constant.
Again, I'm not a climate scientist, but I don't believe so.
The recitals also state that to further geologic storage of carbon dioxide, a potentially valuable commodity, may allow for its ready availability if needed for commercial, industrial, or other uses, including enhanced recovery of oil, gas, and other minerals. Does any of that apply to the Summit project?
Read that one more time.
To further geologic storage of carbon dioxide, a potentially valuable commodity, may allow for its ready availability if needed for commercial, industrial, or other uses, including enhanced recovery of oil, gas, and other minerals.
So, as I mentioned before, right, these recitals are codified to a large extent under 382201, which also reads, further geologic storage of carbon dioxide, a potentially valuable commodity, may allow for its ready availability if needed for commercial, industrial, or other uses, including enhanced including enhanced recovery of oil, gas, and other minerals. And as I testified earlier, the recitals are talking about the policy as issued by the North Dakota State Legislature in 382201.
With the implication being that they apply to your project though, right? Sure. And that one doesn't. That's a question. Sorry, it was a bad question. Does anything in the recitals, section B, apply to your Summit project?
Well, I'm reading it, and it says, to further geologic storage of carbon dioxide, which we are doing.
And is the carbon dioxide that is going to be stored by the Summit project going to be readily available for commercial, industrial, or other uses, including enhanced oil recovery of oil, gas, and other minerals?
Not under the current sets of agreements, but potentially it could be.
If you change the law?
If I change the law, excuse me. I don't understand the question.
Meaning that, well, let me back up. In order to get your tax credits for your project, you have to permanently sequester the CO2 underground, right?
Yes, for the current customers, yes. Or partners, if you will.
At what point are you going to switch your 45Q credits over to the EOR credits?
We don't have any plans to do that.
When do you think you will?
Again, I said we don't have any plans to do that.
So you're going to do the first 20 years and then do that?
I would just say we don't have any plans to do that.
Have you talked about it?
Have we talked about,
Switching to the UR credit?
we have not.
Are you going to pull the CO2 being sequestered in your project back out of the ground at some point?
That's not the plan.
Could be the plan, though, if it changes.
I would say it's the current contracts require us to permanently store it. Right?
Which contracts?
What's that? Our agreements
Agreements with whom, though?
with our plant partners.
Is that because they need it to be permanently sequestered in order to get their low carbon fuel standard credits?
That's my understanding.
How long are those agreements locked in for?
Can you speak up just a little bit?
Sorry, how long are those agreement terms?
I have not seen all of the agreements, so I don't know the terms.
Would it be fair to say that the CO2 is going to get stored there until 2040?
I don't know that that's fair.
Okay. Is it possible that you will withdraw CO2 from the reservoir before the year 2040?
Again, it's not part of our plan. It might be technically possible. I believe it would be economically prohibitive, and it's not part of our plan.
Are there any legal barriers that you have identified that would prevent you from doing that, other than your contracts with the partners?
I haven't analyzed that to determine. Again, not part of our plan.
If you made a plan to withdraw CO2 from the reservoir, would the landowners receive any additional compensation?
Defer to you, Jeff.
Sure. Again, not our plan, as Wade testified. Under the existing contract, there is no additional compensation for the removal of CO2.
Have you ever reviewed any gas storage agreements?
Nothing specific or lately.
Have you seen gas storage agreements with pricing structures that require payments both for things being injected into and taken out of the storage facility?
I have not.
Are you aware that that's the most common price structure for a gas storage agreement in the United States?
Sure.
Does Summit intend to compensate the landowners for the withdrawals of gases at any point if it starts withdrawing CO2?
Asked and answered.
Sustained.
Have you done technical feasibility studies on your ability to withdraw CO2 from the reservoir after injection?
We have not.
Have you done any kind of research or study on that?
We have not.
Why do you say that you think it would not be feasible to withdraw the CO2 then?
I say that I believe it would not be feasible because when you withdrew the CO2, you'd have to separate it from the rest of the, from the fluids and separate out the CO2, compress it, transport it, and then re-inject the other fluids. And so from that perspective, you would take the CO2 from the line first. But again, I haven't done any studies on it to validate costs, or it's just from my general knowledge or understanding of how this, would work under the question you were asking.
Is it your understanding that after 20 years, these facilities will stop taking further injections?
It's my understanding that we are permitting these facilities for 20 years, that those permits will be reviewed and updated every 5 years, and the time frame, could change if the CCS continues to be a commercially viable solution.
But the facilities are still going to fill up at some point, right?
Yes, at some point, the facilities would be full.
What do you do with all the CO2 coming through that pipeline when they're full?
Well, then we would permit additional facilities, or, assuming we needed additional storage, at that point, we would proceed to permit additional facilities.
Might those facilities include things other than storage?
So your question is, might they?
Correct.
I guess that's possible.
Would it be accurate to say there are no plans to shut down the flow into that pipeline when these storage facilities are full?
I would say that we have designed the project around 20 years. We haven't contemplated plans to shut it down afterwards. It's just that is the estimated, project life at this point. But there are no plans to shut it down when the facilities are full. Again, I think it'll come back to a, commercial considerations of their viable options at that point in time.
Do you have a permanent required offtake agreement as a term of the agreements you have with your partners?
Say that one more time.
Yeah, that was bad. Let me start over. Do you have any contracts with your partners that require you to permanently take all of the CO2 coming out of their ethanol plants for the life of their facility?
Again, I'm not aware of all the details of those contracts. I haven't reviewed them, so I can't answer that question.
Well, it's just a general question too, though. Is the idea or the commitment being made by Summit that they're committing to take all the CO2 from these plants for the life of those plants, or is it just for a 20-year project period?
I don't know the term of how long.
That's pretty fundamental to the entire project, though, right?
Certainly the offtake agreements, I would say, yes, I would agree, are fundamental to the project. What I'm telling you is, I don't know the specific duration of 57 different contracts, because I haven't reviewed them.
Can I have you go to the definitions? In the storage agreement. Real quick on the last question, have you had any of your partners renew any contracts at this point for offtake?
Yes, I'm aware of renewals.
How many?
I don't know. I'm just said I'm generally aware that we've renewed. I don't know how many.
Have you discussed plans to expand the geographic area of your storage facilities where they exist right now in the future as a way to increase your storage capacity?
So we have secured agreements with landowners that own about 145,000 or over 145,000 acres. Yep. Our project is much like a mine mouth coal plant operation in that we have a very large capital investment, $8 billion, that's dependent on utilizing a resource at the end of the line, much like a coal plant has. My mouth coal plant is dependent upon the lignite coal resource. And so they, in those operations, have secured generally or leased hundreds of millions of tons adjacent to the plant. Initially, they'll permit a portion of that, develop it. As they continue through operations, they'll permit incremental reserves over time. I would anticipate, that's why we lease such a large area. Now, we don't have current plans in terms of a application or a specific design, but we secured pore space leases over a larger area with the intent at some point in time having the optionality to permit additional areas and develop additional resources. But we don't have specific plans, which I believe is what your question was.
But if you wanted to, for example, simply expand the boundary of one of these storage units, what is the limiting factor on how much more CO2 you can put in? Is it simply the geographic size of what is permitted, or is it related to the pressures at which you're injecting?
Yeah, that's going to be, I would say that's perhaps a better question for the reservoir engineers. But certainly there's a variety of factors that would come to play there. It would be the design of the facility, the geologic characteristics and the reservoir performance and all of these different factors.
Have you done modeling to determine how much further out from the injectors past the boundaries of the current storage facility you could extend the plume in those storage facilities?
We have not. We ran our simulations for 20 years.
On page 3 of the storage agreement in the definitions, this is back to Exhibit 1A. There's a definition at 1.10 for storage expense. It states it's all costs, expenses, or indebtedness incurred by the storage operator pursuant to this agreement for or on account of storage operations. Can you tell me generally what costs, expenses, and indebtedness would be covered by this definition with respect to Summit's actual costs, expenses, and indebtedness for this project?
Is it referenced elsewhere in the agreement besides the definition?
I don't know.
Here we are. Storage expense.
Do you mind if I help?
Oh, no, go ahead.
Okay, take a look at 11.3.
No, almost there. Yeah, 11.3 references under Article 11, relationship of parties. 11.3, pore space owners free of cost. This agreement is not intended to impose and shall not be construed to impose upon any pore space owner any obligation to pay any storage expense unless such pore space owner is otherwise obligated. So I would suggest that it was a definition intended to come back to reference that section, which is all costs, expenses, or indebtedness incurred by the storage operator. As sort of a comprehensive definition of any expenses that are not allocated to the pore space owner.
Can you give me a few examples of costs and expenses or indebtedness incurred by the storage operator pursuant to this agreement for or on account of storage operations?
Sure, lease operating costs or other things are not intended to be imposed upon the pore space owners.
What are the lease operating costs for the leases here?
So a lease operator would be someone who's working on the project or other sort of expenses in relation to the operation of the facilities. What I consider storage expenses.
Okay. So the lease operator, you're referring to the pore space leases with the landowner and Summit as the operator?
Yes.
Okay. And those are the expenses for the operations related to those pore space leases, right?
That is correct.
And so storage expense as used here doesn't cover the amounts paid for the pipeline easements for the Midwest Carbon Express, correct?
I don't know that that's correct. Can you repeat that question?
Well, let me ask it. I thought I knew the answer, so let me ask it. Do storage expenses as defined in the storage agreement as all costs, expense, or indebtedness incurred by the storage operator pursuant to this agreement for or on account of storage operations refer to the payments made for easements for the Midwest Carbon Express pipeline?
I'm sorry. I need it again. I want to be clear on this one.
Yeah. Steph, would you mind reading it?
Question, do storage expenses as defined in the storage agreement as all costs, expenses, or indebtedness incurred by the storage operator pursuant to this agreement for or on account of storage operations refer to the payments made for easements for the Midwest Carbon Express pipeline?
The question is confusing. I can answer it this way. I believe that the definition is comprehensive and that pursuant to Article 11.3, that it is not intended to impose any of those costs upon the pore space owners.
What confuses you about the question?
The length, for starters.
Okay, I can shorten it up for you.
Sure.
Lease operating expenses, you're referring to that as the expenses of the operator, right?
Well, you asked for an example.
Okay. And you're saying.
So
lease
I was
operating
not
expenses.
comprehensive in all.
Right, but that's
Okay.
one.
Sure.
Okay. Has Summit paid money for easements for the Midwest Carbon Express pipeline?
Yes.
Is that money that you paid for those easements something you would consider a storage expense as defined under section 1.10 of the storage agreement?
I believe it falls under the overall costs and expenses of a storage operator.
How about the cost of the pipe?
Are you talking about cost to the pipe for the pipeline, or are you talking about cost to the pipe for the flow lines?
That's a fair question. I mean, for the main pipeline, the Midwest Carbon Express pipeline.
If you know.
I don't know.
You don't know if the cost for the pipe for the Midwest Carbon Express pipeline would be considered part of the storage expenses as they are defined in the storage agreement, section 1.10?
I don't know that I'm the best person to answer the question with respect to all things that would be considered a storage expense.
Did you draft that definition?
I worked and oversaw the development of this, yes.
Well, what did you mean when you wrote it?
I think, as I was testifying earlier, it was intended to create, as listed in 11.3, cost-free to the pore space owners. Much like an oil and gas lease, that they're not intended to pay for the expenses of the injection operations.
But there's never a question that any of those oil and gas lessors need to pay for the Dakota Access Pipeline, is there?
No.
So why would the people in the storage facility have any concern with the pipeline from Iowa? Let me ask a different question. Are you telling me that all the expenses for your pipeline are included in the storage expenses for the storage facility?
I guess I'm not sure I'm understanding the line of questioning.
Do you understand that question?
Can you rephrase it?
Are all of your expenses for the Midwest Carbon Express pipeline considered expenses incurred by the storage operator on account of the storage operations?
I would say yes.
So is that pipeline part of what you're asking the commission to give you a permit for today?
No. If you're referring to the pipeline in front of the PSC, the answer is no.
Well, I don't mean a siting permit. I'm asking you, when you refer to the storage facilities you're asking the commission to permit, are you including your pipeline to Iowa in that?
No.
Okay, why don't we stop here and take an hour for lunch?
Okay.
We are back on the record. Mr. Broughton, I believe you were questioning Summit's witnesses.
Thank you, Your Honor. There's a short discussion, Mr. Boeshans, about mine mouth plants, and I think you were explaining how North Dakota's mine mouth plants work as an analogy for the Summit project. Is that a fair statement?
That's correct.
Okay. Is it your testimony that the lignite mines and the mine mouth plants in North Dakota are a single source?
I can't testify to the agreements that exist between all of the mines and all of the plants. Because they all have contracts, differing contracts and contract terms. My point is, those utilities and/or co-ops made significant investments and entered into relationships with, or contracts with their coal providers that required the coal provider to provide them the fuel they needed to run the plant, or the resource, said differently, for decades. And many of those have survived now for greater than 50 years. The similarity to Summit situation is that we were investing $8 billion to move CO2 to Oliver and Mercer County. And so consequently, we've secured to date over 145,000 acres of pore space. And today we're considering permits to develop 90,000 acres.
You were an executive at a coal mine, right?
I was.
Do the coal power plants and the coal mines have different industrial classification codes?
I don't recall what their industrial classification codes are.
If they use different industrial classification codes, would that indicate to you that perhaps Summit should consider something similar by way of analogy?
I'm not an expert in those codes and classification codes, in terms of how they're used for tracking. I really can't answer your question.
Do the words other non-hazardous waste treatment and disposal describe the storage facilities?
Say that again. Read that again.
Other non-hazardous waste treatment and disposal?
Again, I'd have to look at all of the codes to say which one fits the best.
Well, and I'm not
Again-
asking what fits the best, but do those words describe the Summit storage facility? Let's break it down. The emissions, the CO2 is coming from emissions from ethanol plants, right?
Correct.
Would they consider that a waste stream coming out of their emission stack?
Coming out of their stack, they would, yes. I presume.
Are you, and we've talked about how you don't have any plans to pull the CO2 back out, right?
Correct. Back out of the reservoir, you're saying?
Correct. Can we agree that CO2 is non-hazardous?
Yes, in the atmosphere, for sure.
So other non-hazardous waste treatment and disposal, do those words just generally describe what Summit's doing with its storage facilities?
I would say the way you've described it, yes.
Okay. Are you aware that 221112 is the industrial classification code for fossil fuel generation.
I'm not.
Are you aware that 212114 is the industrial classification code for surface coal mining?
I am not.
Does fossil fuel generation describe the lignite power plants in North Dakota, generally speaking?
Yes, generally speaking.
And does surface coal mining describe the lignite mines at the mine mouth plants in North Dakota, generally speaking?
Yes, generally speaking, yes.
And you'd agree that a fossil fuel generation plant is a different facility than a surface coal mine?
Yes.
There was testimony earlier that you would do your level best to not put surface facilities on an unleased landowner. Why can't you just put into the Exhibit D lease no surface access for the unleased landowners?
The Exhibit D in the storage agreement?
Sorry, yes.
Okay, go ahead, Jeff.
Sure. To the extent that we had a clause for no surface facilities, I don't know that it would be difficult to add that to the lease.
Well, can,
We know that some access may be necessary for things such as seismic or other things.
is that something that you would know well in advance?
I think that's safe to say.
So is it also safe to say that the Industrial Commission could include a provision allowing no surface access for unleased mineral or unleased surface owners? And if you needed any relief from that, say to conduct seismic, you could always come back and ask for that, right?
To be clear, you use the term no surface access, and I probably should be clear about it's a no surface facilities clause.
What can you do other than put facilities on the surface with a no surface access clause that you have in your leases?
To the extent we'd be required, we would continue to negotiate and work with landowners for purposes of seismic or other times we would need to enter into the land, thus access.
So if you had agreed to a no surface access provision with a landowner, sorry, let me start over. With respect to the provision you've referenced, that is a no surface access provision that was included in some of Summit's pore space leases. Is it your testimony that Summit would still be allowed to conduct seismic operations on those properties, even with the applicability of that no surface access clause?
This may be a good time to make sure that my testimony is straight. I may have used the term no surface access in general terms. What it is a no surface facilities that we've offered to the landowners across the board. So to the extent that I said that differently, that was not intentional.
Specifically, does the provision state, unless otherwise agreed in writing, lessee agrees that there will be no facilities, including well sites, pipelines, power lines, or other surface facilities on the following described real property, and then it would go on to describe whatever lease.
Yeah, that's correct. Thank you for
Okay.
bringing that up. That's the clause.
And so what the version I have at least states as the title before what I just read, no surface occupancy. And so is it a fair statement that the no surface access or no surface facilities clause that we've discussed, let's call it a no surface occupancy clause for a moment. Regardless of what we call it, we're still always talking about the same clause, right?
Yes.
And with respect to that clause and the leases in which it appears with Summit and in the pore space owners, is it your position that Summit still has the right to go on and conduct seismic operations even on property with a lease that has that no surface occupancy clause?
Yes.
Did you hear concerns from landowners about seismic operations?
Yes.
What were those concerns?
Concerns about distances from existing water wells?
With respect to the storage facilities, is Summit asking to amalgamate the interests of just the unleased owners?
That is correct.
But is it intending to impose the provisions of the storage agreement with the attached pore space lease on all owners, leased or unleased?
So, Mr. Broughton, as I testified before, I do believe that yes, it does. But it also, we have written agreements with the existing leased owners that we feel would govern with respect to the terms of the lease.
Can I have you look at section 3.3 of the storage agreement?
Sure.
So you're able to testify that you're going to honor those other leases because in section 3.3 of the storage agreement, you're going to impose on everyone, leased or unleased. It states that the provisions of the various leases, agreements, or other instruments pertaining to respective tracts or their storage and storage substances therein, including the pore space leases attached hereto as Exhibit D, are amended to the extent necessary to make them conform to the provisions of this agreement. Did I read that right?
You did read that correctly.
So anyone who signed a lease is having their lease conformed to this storage agreement, no matter what they negotiated with you. And that's what you're asking the Industrial Commission to do right here, right now. Did I get any of that wrong?
I don't necessarily agree with that.
What do you disagree with?
I think the two work hand in hand still.
What two?
The storage agreement and the pore space leases that we've entered into.
How so?
Because it says that they shall otherwise remain in effect.
But only to the extent they are now in perfect conformance with the lease that you have submitted to the Industrial Commission to impose, right?
Perhaps, but I know that Summit's intention is to honor the lease agreements that we've entered into.
Then why doesn't it put that intent in writing that it's asking the commission to do today?
I'm not sure.
Would you like to ask the commission to do that then?
Yeah, I think so.
Yeah?
I think it would be fair.
So we're going to amend this provision to allow all of the pore space leases signed to remain in full force and effect and not be abridged in any way by the storage agreement submitted here.
I think I'll defer to council on the best way to amend it rather than testify to it.
Okay. Up above in the definitions, there's a storage facility participation as a term, and then that refers to, well, I'll just read it to start. It says storage facility participation, sorry, I'm on page 4. Is the percentage shown on Exhibit C for allocating payments for use of the pore space under each tract identified in Exhibit B. So I think I will start with Exhibit C if we can. Would it be accurate to say that when you listed the tracts, all right, let me start that over. Would it be accurate to say that the tracts listed were identified as all of the acreage that is both in the storage facility and in any given section, and that would be one tract?
I think so.
That was a bad question, sorry. So let me just, tract number 1 includes all lands in section 27 that are also in the storage facility, is that right?
The one I'm looking at is maybe different. I'm looking at
Oh, sorry.
storage 1, but I anticipate that your question is, the answer is yes.
Yeah, let me grab the one you're on real quick. Okay, so tract 1 refers to section 34 on the application you're looking at in Exhibit C to the storage agreement, is that right?
It does.
Okay, and so it's only 120 acres, and I'm presuming that that is because tract 1 includes all acreage from section 34 that is also in the storage facility. Is that accurate?
That is accurate.
And is that how you determined each separate tract would essentially be a separate section and all of the land from that separate section that is also within the storage facility?
That is correct.
Okay. And so just as one example, track number 1 refers to section 34, township 142 north, range 87 west, and that has 120 acres and a tract participation factor of 0.40754336%. Would it be fair to say that that is the percentage of the total acreage that tract 1 makes up of the storage facility?
Yes.
Okay. And so if we go up to Exhibit B,
Did you say B or D?
Exhibit B as in boy,
Thank
and it is the tract summary. In there again, we have tract number 1, section 34, township 142 north, range 87 west, 120 acres. But we have 3 different owners of interest, each with, we'll just say 40 acres each. And so they each have 33.3% tract participation, and that is the tract participation factor for that tract number 1 and their interest in it. Is that accurate?
Yes.
Okay. And then the storage facility participation would essentially, well, let's just go straight across the top line for Gerald. So essentially what this means then is for tract 1, and I don't know if Gerald may have other tracts, but let's say that Gerald just owns tract 1. What this says is that Gerald's interest in that tract is 33%, and therefore you would multiply that. Well, actually, how do you get from the tract participation to the storage facility participation?
Sure. Grab one number and I can explain it. May I see Exhibit 5A? I think we have it below us here. I have it. So I would. Exhibit 5A shows that the total acreage for the Summit Carbon, or for the SCS 1 TB Land Gang as 29,444.72 acres. If you were to divide 40 by that number, you would see that Gerald, he pronounces his name Gerald,
Oh, thank you.
at 0.00135848 or 0.13584799 or 779.
Okay.
Sorry.
So the
Percent.
storage facility participation number would be the proportionate share of the acreage for that individual landowner based on their interest in that tract, if we are following their name across the row in your Exhibit B. That was bad. Let me start over.
Okay, thank you.
So let's start with Gerald. If we go across, that storage facility participation number is 0.13584779.
Correct.
That would be his, in putting aside potential other interests, but if we assume this is his only interest, what that is indicating is that's his proportionate interest in the storage facility based on his percentage interest in Tract 1.
That is right.
Okay. How did Summit determine which landowners it would ask the commission to amalgamate for its projects? And just so I'm not confusing you, I'm not trying to ask for names here. What I mean is, how, not the people, but how did you decide which tracts of property or what land you needed to amalgamate for purposes of the project and the applications?
Sure. The unleased landowners inside the storage facility boundary.
Okay. Why the ones that are inside the storage facility boundary?
So development of CO2 or CO2 storage projects requires the cooperation of multiple parties. And because their land is internal or inside of that boundary, we know that it will be impacted, or said differently, have CO2 stored in it. And that's why we're seeking to amalgamate that interest to develop the rights of the other 93% on average.
How was the storage facility boundary determined?
By the geologic model.
Based on landowners that need to be amalgamated, or what was the basis for the boundaries as set?
Yeah, so if I can help with that one. So the storage facility design, or said different, simulation determines the boundary or the plume extents at the end of 20 years of injection. And then we also modeled the stabilized plume. And then established the boundary outside of that, generally following describable lines. Okay, we didn't have curved lines, we followed a describable boundary that included buffer around that.
How far did you place the storage facility boundary from the extent of the modeled plume?
The boundary was not always consistent. In other words, we didn't just use the same buffer everywhere.
What's the range?
Don't recall specifically. I would say it ranges between 500 feet, 1,000 feet, somewhere in that neighborhood, for my recollection, and maybe as much as half mile or so.
With respect to the modeled CO2 plume, that line was drawn based on literally what the model generated for the external boundaries of that plume, right?
Yeah, let Amanda testify more specifically to that, but that was my understanding is we were looking at the model output for the plume boundary at the end of 20 years of injection. And then additionally, the plume boundary or the stabilized plume boundary approximately 16 years later, or I forget exactly the number, but the stabilized plume boundary. And that's what, then we developed the storage boundary outside of that.
Did someone at EERC make the decisions on the extent of the buffer area between the stabilized plume boundary and the buffer zone, or the storage facility boundary?
No, they had input on it, but we made the decisions, Summit made the decisions.
Based on what considerations?
Based on all the things I mentioned, along with kind of the which included, describable boundaries, reasonable buffer, and participating landowners.
So you did draw the boundaries to exclude unleased owners that you weren't able to get leases from?
So if we had adequate buffer, we would not try to minimize the amalgamation or the force.
How do you determine whether the buffer is adequate?
Basically, we know that the boundaries, if you will, that are identified, by the modeling are on 1,000-foot blocks, 1,000-foot grid cells, and 5% saturation. So we know what we start out with. It's fairly thick to begin with. And then ultimately from that we look at what is a reasonable boundary or buffer that we have. I would describe it as confidence the plume will stay inside of, and have, call it, margin for error.
What was the range of the buffer area from the plume limit?
As I recall, it was around 500 feet to a half mile, maybe more. Again, I have to go back and look specifically, or would have to look specifically at those. I don't recall them off the top of my head.
But you're saying the model was using 1,000-foot blocks?
Yes, the grid cell size was 1,000 feet, as I recall it.
Why 5% saturation and not something lower?
I'm going to defer that one to the ERC team.
Why did you use 5%?
I used 5% because that's what the standard that the ERC had indicated had been used in other permits, to my knowledge.
Do you have any actual testing?
What kind of testing?
Any?
Again, what kind of testing?
Testing to determine the saturation.
No testing to determine the saturation. It's predicted by the model, from my understanding.
if you're using 1,000-foot blocks, how can that model tell you anything about where to put a buffer in a 500 to 2,000-foot range?
Again, I'm going to defer that to the Reservoir Engineering and Geoscience team that is more knowledgeable on the model and the software and its reliability and predictability and how it's been used.
Is it your understanding that a change in the 5% saturation could change the extent of the plume model?
Again, that's outside of my specific area of expertise and knowledge on how the model works. But I would anticipate change of saturation would potentially could change the boundary, push it into a different cell.
And it's your testimony that EERC is the one who made the decision on, well, let me start that over. With respect to the saturation percentage, generally speaking, is it your testimony that the folks at EERC made the decisions related to that percentage and the modeling?
The ERC team of experts made a recommendation to us on percentage saturation that, as I understand it, was consistent with what other projects had done. And that's what we used in developing the permit application. But again, they'll be testifying later. They can speak more specifically to the exact methodologies and workings of the software.
Is there any reason you would want to hide that data from further review?
Hide what data?
The data used by EERC to create the model?
Not to my knowledge. I believe it's submitted to the DMR.
The raw data for the model is submitted to the DMR?
I'm going to let them testify specifically, but that's my understanding, is that the model itself has been submitted to the DMR.
Do you know when?
I don't know exactly the date.
Was it within the last 4 weeks?
No, it would have been prior to that.
And you're testifying that the data decks, and the model itself were all submitted to the DMR?
Again, I'll have to, defer to the team that's put all of the submittals into the DMR. It is my understanding that the geologic model was submitted to the DMR.
Is there a reason that you would not want people to have the data to assess that model?
No, I don't think so. It's my understanding that once submitted to the DMR is publicly available. But again, my understanding.
Can I have you turn to section 1.15, the definition of storage reservoir? I'll ask a quick question first. I was going to ask some questions about, for example, the variation or range of vertical depth of pore space throughout the reservoir. Would those be better for the EERC folks?
Yes.
Yeah, okay. Let's go down to 1.16 for storage rights then. From where does Summit obtain storage rights to explore, develop, and operate lands within the facility area?
Jeff, I'll defer to you.
So, I'm a little confused by the question. Are you wondering, well, maybe you can ask it in a different way so I can understand the question.
Does Summit have any rights to explore, develop, and operate lands within the facility area for the storage of storage substances, as those words are used in section 1.16 of the storage agreement?
Yes, under the terms of the lease.
Which lease?
To the extent that we have leased owners, and then this would tie back, of course, to the lease that we've attached as Exhibit D.
Okay, so as defined, storage rights are the rights to explore, develop, and operate lands within the facility area for the storage of storage substances. In your testimony is that the source of those rights is are the leases signed with the individual pore space owners, as well as the lease attached as Exhibit D to the storage agreement. Is that accurate?
I think that's fair.
When you sign a lease, one of the pore space leases with one of the landowners who signed, how is it that you get rights from signing a contract with them?
Well, I think the question's basic, and I don't mean this to sound wrong. We've entered into a property right agreement
Yeah,
through the terms of a lease.
yeah.
Is that the question you're asking me?
And are they conveying property rights to you in exchange for money?
Yes.
And so in that situation, it is a consensual transaction by which that landowner transfers specific property rights to Summit.
That is correct.
In the case of Exhibit D attached to the storage agreement, there's no consent from any landowners. So by what power is that imposed on a landowner, if not by his consent?
If the commission were to enforce Exhibit D, the rights to inject and store carbon dioxide under the terms of that lease would exist in paragraph 4, but I understand that that's an imposed lease.
And what power does the commission have to impose a contractual document on a North Dakota citizen?
That's more of a legal question.
Are you a lawyer?
I am. So, that's the powers granted by the legislature in 3822 to allow for the amalgamation is the power that is granted to the commission through the legislature.
And what is the commission doing when it amalgamates property rights?
Again, not trying to be flippant. I mean, they're amalgamating the rights. I mean, can you expand on the question? I'm not sure I understand the next.
After the commission amalgamates property rights, does Summit end up with some property rights that previously belonged to a landowner?
I would say yes, that's fair.
Because the commission took it from them and gave it to you?
Wouldn't characterize it like that. I think the commission's working under the authority granted to it by the state legislature.
Authority to take private property, right?
To amalgamate interests across multiple owners for the development of CO2, I understand the question. Yes, it is.
And in order to
agreement.
amalgamate the owners, what you're doing is taking their property rights and telling them, you no longer have the right to exclude me from your property. I'm coming on whether you like it or not. And that means that you now have a property right, the right to exclude, that they used to have, but now they don't have. And you do have, all by virtue of the commission order. Is that accurate?
Objection, argumentative, compound.
Sustain.
Can Summit operate this storage facility without amalgamating it?
No.
Why not?
Well, much like oil and gas, in order to develop a resource, in this case pore space, would require the cooperation of multiple landowners for development into that formation.
And what happens if they don't cooperate?
The same thing we've just discussed, which is a order for amalgamation.
What happens in oil and gas when they don't cooperate?
An unleased landowner has certain statutory rights regarding the development of oil and gas.
And you do oil and gas law, right?
I do.
They get their just and equitable and their proportionate share in the reservoir, right?
So a non-leased landowner in North Dakota who decides to go non-consent to a well is subject to a risk penalty. And upon completion of that risk penalty, they are entitled to their proportionate share of the minerals that they reserved or own in that particular unit. And I believe there's a statutory provision for a royalty along the way.
So essentially what they get is a 16% interest cost-free, meaning on gross, and the remainder 84% on net revenue,
After the imposed risk penalty.
which is statutorily prescribed to be just for oil and gas.
Yes, that's true.
So if we want to apply oil and gas law to the Summit project, let's go up to Exhibit B. specifically Exhibit B, the tract summary attached to the storage agreement. Gerald's just and proportionate equitable share, if we were talking about an oil and gas reservoir, would be 0.135847779%, right?
Yes.
And under the oil and gas laws you were just talking about, it would be that percentage split out into a 16% on gross and an 84% on net revenue.
In oil and gas, when it is the extraction of an existing mineral, yes.
Right? Because that mineral isn't owned by the operator necessarily, it's owned by the mineral owners.
That's right.
Just like the pore space is owned by the surface owners.
I understand, yes.
Can I have you turn to section 2.4 of the storage agreement in the application, Exhibit 1A? There's a section 2.4 on correcting errors, and the second sentence says, if it subsequently appears that any tract, mechanical miscalculation, or clerical error has been made, storage operator, with the approval of pore space owners, shall correct the mistake. Can you just tell me what is meant by mechanical miscalculation?
Can I help?
Yeah,
I
please.
think that's a typo. I think it should say mathematical.
Okay. That makes more sense. Okay, so in the same exhibit at section 3.1, we had some discussion of this, but it states that any pore space owner in the storage facility who owns a pore space interest in the storage reservoir that is not leased for the purposes of this agreement and during the term hereof shall be treated as if it were subject to the pore space lease attached hereto as Exhibit D. Is Summit willing to adjust that Exhibit D to ensure there is no surface occupancy as it has done for some of the signed lease owners?
Yes, we would do that.
Okay. have you go down to section 8.1 of the storage agreement. 8.1 states, grant of easement. Storage operator shall have the right to use as much of the surface of the land within the facility area as may be reasonably necessary for storage operations in the injection of storage substances. Does that apply to unleased lands, surface lands?
As written today, it does.
And would Summit also change that provision so that it does not apply to unleased surface lands?
Yes. I think it was implied in my answer that consistent with the leases that we sent to everybody in the the fall of 23, and again in the spring of 24, we've included that no surface facilities clause. And so it's an easy thing to provide. And so we can add that to the Exhibit D pore space lease,
Okay.
and then it would have its impact in here as well, if that's the question. Subject to Exhibit D.
Okay, as it's written right now, with the landowners who have signed leases with Summit, do their leases give Summit explicitly the right to use as much of the surface of the land within the facility area as may be reasonably necessary for operations?
No, it does not.
Okay. So this is granting additional rights to Summit to use the surface of property that is leased as well as unleased?
So as I testified earlier in direct, we do not anticipate additional surface usage specifically towards facilities, roads, pipelines, etc. There may be needs for ingress and egress for purposes of various studies or otherwise.
And are you saying that if your existing leases and agreements with the landowners don't give you those rights of ingress and egress, you're asking the commission here to grant those rights to you regardless of whether you have them in the private contracts? Is that accurate?
No. Our existing leases do have rights of ingress and egress.
Okay, so I want to back up though. Do you think that this provision 8.1 gives Summit any rights on the surface of landowners who have signed leases that aren't already explicitly in the lease?
So it, in its language, it states as may be reasonably necessary
In the lease or in this?
in this
Okay.
clause.
And that's,
So-
sorry, go ahead.
I'm sorry too. Storage operator shall have the right to use as much of the surface of the land within the facility area as may be reasonably necessary for storage operations and the injection of storage substances. I read that sentence in its entirety, and there is an imposed reasonableness standard on what's there. So unless it's reasonably necessary, I think it's limited by reasonably necessary.
Does the grant of an easement to do what is reasonably necessary for your operations expand your rights to use the surface of any of the lands that are leased?
I don't believe it expands the rights when we have an existing lease. We have an existing written contract when there is a lease.
So it's not your intent to obtain any rights to use the surface beyond the rights explicitly granted in your leases with respect to the properties that are under lease?
With respect to the properties that are under lease, that is correct.
And with respect to the unleased properties, would it be accurate to say that you're asking the commission to give you the property rights necessary to do what is reasonably necessary for your storage operations on the surface of those unleased lands?
Yes, that is correct.
By what authority do you think the North Dakota Industrial Commission can grant anyone the right to use the surface?
I'm going to object with respect to his characterization of anybody. We're not talking about anybody, we're talking about the operator, the storage unit.
That's fair. I'll withdraw the question and re-ask. By what authority do you think the North Dakota Industrial Commission can grant Summit property rights sufficient to allow it to do what is reasonably necessary for storage operations on the property of the intervenor landowners I represent?
So the North Dakota Industrial Commission is operating under North Dakota Century Code, Chapter 3822, and its administrative rules, which I believe are 430105. I might have that backwards. 0205. Allow me to look. 430501.
Oh, we're both wrong.
And so I think that the authority to answer your question comes both from the legislature and the Century Code, and then based on the rules that they've developed.
What provision of Chapter 3822 provides any authority to do anything amalgamation or otherwise to the surface lands as opposed to the pore space?
I would say under 382203, entitled Commission Authority, which reads, Commission has authority over all persons and property necessary to administer and enforce this chapter and its objectives.
So are there no limits on the commission's authority as long as that's what they're doing?
I think that's a mischaracterization.
Well, I'm asking, I'm not saying that's what you said.
Certainly there are limitations, much like the reasonableness standard that's in the draft storage agreement.
And what are those limitations?
I would say limited to the extent necessary to develop and store CO2 under Century Code.
Would you agree it's also limited by the mandates and prohibitions of the Constitution of North Dakota?
So I'm not a constitutional lawyer. I don't know that I have an opinion on that.
Well, as a lawyer, do you support and uphold the Constitution as
I
a
do.
practicing lawyer?
Yes, I do.
Does that trump the other law?
Does, when you say that,
The Constitution.
Mr. Examiner, I think we're getting into areas now where we're arguing legal issues, and I don't think this is the appropriate way to make those illegal arguments.
Sustained.
Can I have you turn to section 8.4 of the agreement that we're looking at? There's a reference to the surface and subsurface operating rights. And it references use of water. Can you explain the ways that you understand Summit intends to use water from the reservoir in the formation?
Yes, I would say this is more of a question for the drilling operations and that team. My understanding is that as we drill the well and maintain the well, we have needs to pull samples or move fluids in and out of the reservoir during the drilling and completion process, but they can speak more specifically to that.
Are the drilling folks the folks from ERC?
No, they're members of our team.
Okay, and is it like a separate drilling, like consultant, or they're actual employees of Summit?
We have employees of Summit that will be testifying here.
Okay. Are you asking in this provision for the commission to grant property rights or ownership rights to the water, or just the ability to use the water in the drilling operation?
Yeah, I'm going to defer to Jeff here as well. My understanding is that we're requesting the permission to use the water as needed to facilitate operation and injection of CO2.
So I'll ask a couple questions just to kind of explain what I'm getting at here.
Sure.
Are you aware that, generally speaking, until put to beneficial use, water in North Dakota is generally all considered waters of the state? And so to the extent any waters in the reservoir have not been put to any kind of beneficial use, they may be deemed to be waters of the state. And so my question is simply, and here are you asking to be able to use the waters in the reservoir as necessary for your operation, or are you asking for the state to actually grant you the right to that water in that reservoir to use however you please?
Sure. Jeff, I'll let you take that.
Sure.
It's more of a definition.
except to the extent modified in this agreement, storage operator shall have the same rights to use the surface and subsurface and use of water and any other rights granted to storage operator in any lease covering the pore space interests. I understand that to mean the rights to use water where necessary. Our needs for water will be privately contracted for drilling
So just to use perhaps a slightly ridiculous example, you don't have plans and it's not your intent that you would be able to then open up a water depot and start pumping water out and selling it.
That would not be commercially reasonable. I would not, no,
Okay.
absolutely.
And so if we were in the oil and gas context, and you can object, but generally what you're saying is what you're asking for is the ability to use the water in the reservoir as reasonably necessary for your operations. Is that a fair
That is fair.
statement? Okay. Can we turn down now to Exhibit D, the form of pore space lease that we've referred to a few times? It's in the application.
I am there.
In section number 2, under the term, there's a reference to a bonus payment of $20 per acre and an annual rental of $4 per acre for the initial term.
I think you may have misread that, Mr. Broughton. Mine says $25.
So does mine.
What did I say?
20.
You said 20.
Sorry. Let me start that over. So I read this to say they're paying a bonus payment of $25 per acre, and it states that's a single one-time bonus payment and an annual rental of $4 per acre for the initial term. How did Summit decide upon those numbers for the bonus and rental?
Yeah, I would say kind of two ways. We initially started with numbers that were consistent with co-leases and co-leasing that I had familiarity with and obviously my previous experience. They were then adjusted from there based on negotiations with the landowners. Those are some of the terms that changed during the negotiations.
And then, just to follow up on that, there's a Section 3 royalty that has a 50 cent per metric ton. And then later percentage increases. Did you decide on those numbers the same way as the bonus and the rental?
That's how we ultimately started with.
Okay.
And then, again, same deal as through negotiations, they were adjusted.
In the coal leases, are those with just one operator or numerous operators?
You're asking for me for my point of reference?
Yeah.
Yeah, with numerous.
Okay. And those were North Dakota coal leases?
Correct.
Were any of them new leases signed within the last 50 years?
Yes. I haven't been in the business 50 years.
What companies are still leasing coal in North Dakota?
I don't know specifically who's actively leasing or not leasing. Yeah. We were leasing when I was at BNI.
When you were leasing at BNI, had you adjusted the rates you were paying since the 1930s?
We had,
How much? Just percentage-wise?
well, I wasn't there in the 1930s, so
Well, that's fair, sorry. I didn't mean to imply you were.
I know I'm getting gray, but I am gray.
Okay, so how many times did you adjust or change the bonus or rental or royalty amount that you were offering landowners for a pore space lease? And I'm speaking now, sorry, we were talking about BNI, so I'm back to Summit now. In the time with Summit, how often did Summit adjust the bonus, rental, or royalty in response to their negotiations with the landowners?
I'm going to defer to Jeff here as well. I don't recall specifically the order in which the changes were made, but we were moving those around, or adjusting them through negotiations. But I don't recall, was it all at once or in multiple steps? My recollection, it was multiple steps, but I'm going to defer to Jeff and his
Sure. So, we began negotiations in September of '21, made significant offers, and when I say significant, we reached out to a large number of landowners. We started to see some of these leases come in. We received feedback from a number of people, including some of your clients, regarding multiple terms. Those terms included annual rental, and I'm going off of memory. They included increase in royalty, an increase in the extension term bonus. They included percentage increase year over year. They included favored nations and perhaps others that I'm not recalling at the moment.
And I'm sorry, I should have asked that question more specifically, but what I'd intended was just, and let me actually break it down and ask some different questions. Is the $25 an acre bonus, $4 an acre rental, and 50 cent per metric ton the monetary offer made by Summit in the first pore space leases you mentioned that were sent out?
No.
And what was the opening offer that Summit made to landowners?
If my memory serves me correct, the bonus payment of $25 an acre is consistent. The royalty was 25 cents. The annual rental was $2 per acre. And the reason the majority of the changes came together, though discussed with multiple landowners, is primarily due to the favored nations clause, at which point we sent out a first amendment to our pore space agreements to anyone who had signed prior to provide them with the same terms as what we eventually came to from the negotiations on, as I testified, all those 450 plus different landowners.
And so once you had given all of the landowners that most favored nations clause, you were unable to modify things for any additional landowners negotiating with you without changing all the other agreements? Is that your testimony?
With respect to compensation, yes. Well, may I qualify that? Any change applied to everyone.
And so other than the change such as the no surface facilities clause we discussed, or the changes to the compensation level you just mentioned, you simply didn't make changes for other landowners in individual negotiations. Is that right?
I think that's correct, yes.
Changes to compensation.
I included that,
Yeah.
yeah. So other than the coal leases you say you looked at when you started developing this, did you gather any information or do any research or investigation other than that to arrive on monetary amounts to put into the leases?
Obviously, excuse me, with my, in my former role, I was aware of compensation related to Lincota's project. But other than that, at the time, there weren't any other public available references, if you will, lease terms around CO2 projects that I was had access to. And so the only, from a CO2 perspective, market perspective that I had was the one project that I was familiar with.
But,
And
oh, sorry, go ahead.
yeah, so that was kind of, that was, I would describe as the extent of it.
Okay. Can I have you turn to section 17 of Exhibit D to the storage agreement in the application, Exhibit 1A? Sorry, we've got exhibits within exhibits that got a little long, but we are looking at Exhibit 1A, the application. Within that exhibit, there is a storage agreement, and attached to that storage agreement is Exhibit D, which is the form pore space lease. Within that Exhibit D, section 17, I'd like to direct your attention to.
I am there.
Thank you. So this section states that the bonus and royalty amounts contemplated and paid to lessor hereunder is compensation for, among other things, damages sustained by lessor for lost land value, lost use of and access to lessor's land, and lost value of improvements, if any, and to the extent applicable. So if Summit needs to access some of its facilities, and it drives across the farm field planted with wheat, and takes out part of a farmer's crop, and that farmer is unleased, this provision says they don't get damages for the part of their crop that was destroyed, and they've already been compensated with the royalty?
That is incorrect.
Okay, explain how that's wrong.
So under paragraph 11 on page D4, we have our hold harmless and indemnification. The intent of paragraph 17 is essentially acknowledgement that the bonus and royalties are compensation for the use of, in this case, the real property or the pore space. So acknowledging that if we did permanent storage, that that particular reservoir may be unusable in the future. So the clause was intended to be acknowledgement that the compensation would utilize and use that pore space.
So then in 17, would it be accurate to say that the intent is to limit that language as if we added to the end rising out of the ordinary and reasonable operations of Summit? And I'm not asking you to amend it, I'm just trying to make myself understood here, that when you say that the bonus and the royalty amounts are compensation for lost land value, lost use of an access, you're saying it's compensation for lost land value, lost use and access arising from exercising the rights to inject into the pore space, but not, I accidentally started a fire in your field.
You are correct. We are not seeking, your characterization is correct.
Okay, so okay. In section 16, there's a force majeure clause. When a force majeure clause is signed between two parties to a contract, generally speaking, we understand how that's going to work if there's a dispute. But in the event of force majeure here, well, let me start over. In the event of a force majeure event to which section 16 would apply, who would make the determination as to whether it was a legitimate force majeure event for an unleased mineral owner or an unleased surface owner on whom this contract is being imposed by the commission?
I'm sorry to ask the qualifying question. Who would make the decision that the force majeure event happened in an unleased landowner scenario?
Yeah, maybe a better way to ask it is, to whom should the landowner go to relief in that scenario, the commission or a court?
I don't know.
Okay. Let's look at section 18. If a landowner gives Summit a warranty of title and someone else sues Summit saying, I own that property, not Joe over there, does a warranty of title require that landowner to step in and defend Summit and hire lawyers to defend them?
Technically, perhaps, but I'm not sure that's how it works in general practice.
But as a matter of law, that landowner who gave the warranty of title is legally obligated to provide a defense to Summit, because that's literally what the warranty is, right?
Sure. Yes.
And Summit is asking the North Dakota Industrial Commission to impose an obligation to warrant title on a landowner. Is that right?
I understand the question, yes.
That is right.
That is right.
Do you understand how that would even be possible as a lawyer? Because it starts to sound like indentured servitude, doesn't it,
Wouldn't characterize it that far.
on that spectrum?
My answer to warranty of title is generally that, to be clear, common property law, and my experience in property law is that while yes, it does suggest that there would be a duty to defend, it means that your ownership, that you would stand by that and support in the form of documentation or otherwise that would show your ownership. So if there was recorded deeds and everything was in place, that would stand to, that would stand as record title. If there were things such as dresser drawer deeds or deeds to others, late filed or after death filed, recorded, I think we're looking at those types of warranties, that they don't exist, or that to the extent that they're aware.
But if you simply said, the lessor hereby represents that to the best of his knowledge, he has no dresser deeds or stray deeds and not aware of any unrecorded documents, that would all mean exactly what you just said.
Mm-hmm.
But then when you use the word lessor represents and warrants, that triggers all the warranties of title and covenants of title. That includes a title warranty, that includes the obligation to defend, that includes the obligation to hire lawyers to defend Summit. Right?
Fair.
Does Summit believe that the commission can impose a warranty of title on an unwilling landowner to warrant title to another person or company or anyone? Is that what you're asking for?
I think it would make sense that, to the extent the lease indicates what you're suggesting, a modification would make sense. That is not our intention.
But you agree that is what it says.
I don't necessarily agree. I would need to look at it closely. I don't believe that was the intention. But I understand the argument.
I mean, it says lessor hereby warrants and agrees to defend title.
Yes, it does.
Real quick, I just want to note that we had a discussion just now about the warranty of title, and I didn't address that, but there is a warranty as well in the storage agreement at 7.1. Would you agree that similarly there, it was not the intent to impose a title warranty on individual landowners to defend title for Summit?
Yeah, I think that's fair. And for the sake of the commission to know and understand that typically the warranty, and again, this is in practice, if somebody else claims that they own your land, we are asking that you would stand up alongside us and say, no, I own my land. And so that was the intention. I understand the adjustments that may need to be made for that purpose.
Before I leave it again, in the storage agreement at 10.1, there's a provision on transfer of title. I'll let you get there.
Thank you. I'm sorry, I was taking notes. Can you tell me where we're going?
I think I sent us to the wrong place anyway, so that worked out. I'll come back to it, but I do want to check on also 10.2. It's on page 13. Oh, sorry, I'm on a different one. I don't know if my page numbers are the same, but section 10.2, waiver of rights to partition. This is sort of a similar question, but with respect to section 10.2, are you asking the commission to issue an order that landowners have no further rights in perpetuity to bring a partition action of property?
No. So a modification may be required there.
And you'd agree that even if the commission had jurisdiction over an individual, it doesn't have jurisdiction to bar partition actions in perpetuity for a piece of property.
That's correct.
Are you familiar with the process, just generally, that occurs at the end of project and upon certification to the state of North Dakota?
Yes.
Generally.
Let me pull it up here. So in the Century Code 382217, it says that once a certificate is issued, title to the storage facility and to the stored carbon dioxide transfers without payment of any compensation to the state. Are you just generally familiar with that provision and what it means?
I am.
And when that provision states title to the storage facility and to the stored carbon dioxide transfers, can you tell me how you understand, and you not as a lawyer, but you as Summit, or let me ask it better, how does Summit understand the phrase title to the storage facility and what that means?
I would say it is a transfer of the leasehold rights as well as the stored CO2.
And so would another way to say that be to say that it transfers all property rights Summit has in the storage facility to the state as well as the stored CO2?
That is fair.
Okay. Could one of the unleased landowners market the CO2 being stored?
No.
Why not?
Under the terms of the lease and also under the terms of the lease that we intend to ask for in Exhibit D, ownership to the CO2 in exchange for the compensation belongs to Summit, or in that case, the state.
And if there were no lease, would the CO2 being put under land of an objecting landowner eventually be abandoned there as a matter of law? Well, let me ask a different question. You indicated that a landowner couldn't commercialize or market the CO2 being stored there, and it's because of the provisions of the pore space leases signed by individuals or by the provisions of the form pore space lease. If the commission didn't impose that form pore space lease on a landowner, would there be any barrier to them pulling the CO2 out and marketing it?
Legally or technically?
Both. And I understand you can't necessarily speak to all of them, but just whatever you know.
To the extent, so the storage, and in this case, the removal, would require the cooperation of multiple landowners. And so I don't believe technically they could without other agreements.
Why couldn't a landowner put a well directly under their own property, into their own pore space, and just pull up whatever is there?
Because it would likely impact the surrounding landowners depending upon, I understand the question, yes, assuming it didn't impact other landowners.
Can I have you turn to Exhibit 1A to the storage agreement, and specifically to Exhibit D, the form pore space lease to the storage agreement, and then specifically Section 25.
I am there.
And 25 states confidentiality. It says, lessor shall maintain in the strictest confidence for the benefit of lessee all information pertaining to the compensation paid under this lease, any information regarding lessee and its business or operations on the leased premises or on any other lands, the capacity and suitability of any reservoir or reservoirs and subsurface pore spaces, stratum or strata unitized or amalgamated therewith, and any other information that is deemed proprietary or that lessee requests or identifies to be held confidential, in each such case, whether disclosed by lessee or discovered by lessor. Is Summit asking the North Dakota Industrial Commission to impose that prohibition on free speech on unleased mineral owners and surface owners?
We would strike that clause.
Section 34 of that same document has an insurance clause.
We'd be willing to strike that.
Okay. Well, I guess that gets rid of all my questions. Oh, so I have a specific one. Is the intent here that the $1 million limit is a limit in place with respect to that tract in that lease, or a $1 million limit for the entire project?
I'm not sure.
Okay. Is Summit only maintaining a insurance policy with $1 million limit for this project?
No.
So just to follow up, this provision is not indicative of what Summit's actual insurance levels are, but rather what they're providing within a contract as a contractual obligation that they will take on for a landowner. Is that fair?
I think that's fair, yes.
Okay.
Now's probably a good time to take another 10-minute break.
Sure. Thank you.
Off the record. Thank you. We are back on the record. Mr. Broughton, you were questioning Summit's witnesses.
Thank you, Your Honor. So back to the insurance provision, would Summit do a waiver of subrogation with respect to the insurance it's carrying for the landowners?
Yeah, I believe we could.
And would that apply to both the landowners and their renters?
Well, thank you. So waiving rights of subrogation would prevent any insurance company from recovering from who is legally held liable.
But just as to the landowner and their renter is what I'm asking.
I think we could consider that, yes.
And would that be a change then to the, both the Exhibit D form lease as well as the section in the storage agreement we talked about? Wait, no, I confused myself. Never mind. I'm just talking about section 34 of the Exhibit D. Is that a change that could be made there?
I believe we could present something to that effect.
Would the commercial general liability insurance cover that's referenced in section 34 here cover pollution events or contamination events?
I am not sure.
Is that something that Summit is willing to have insurance for that covers the landowners?
I believe we've indemnified under paragraph 11
Okay.
for those same purposes.
If that's true, is it fair to assume that you do have insurance for that?
I would believe we do, yes.
And so with respect to whatever insurance policy Summit has for pollution and contamination events, can it add the landowners who own the property as additional insureds on those policies?
Subject to that language, I think we could add as additional named insureds. Let me verify that with my team.
Understand.
There's a legal term of art there that I would need to address with my legal team.
Okay. Is there a reason for, well, let me ask, with respect to section 34 and the $1 million liability limit, is Summit putting in place a separate insurance policy for each tract?
No, I don't believe that to be the case.
Okay. So is there one insurance policy covering all tracts of land with a $1 million limit?
I believe the limits, yes, there is a policy.
Okay. And can Summit add the landowners to its general liability policy as additional insureds?
I would need to talk to our legal team.
Okay. Does that seem like a fair thing to do if you're forcing those landowners into this facility to take on that risk without any choice in the matter?
I think it seems fair, yeah.
We were looking at the application earlier at, I think, PS 5. Yeah, if you could look at the application page PS 5 with the diagram on it. It's figure PS 3 project summary map. We talked a little bit about the facilities, and I'm going to talk about the facilities after the terminus point. And when I say that, what I mean is essentially everything downstream from the Midwest Carbon Express pipeline. So after that terminus point, we talked about flow lines. We talked about a valve station at the terminus point. And obviously there's the Class 6 injector wells. What other surface facilities will you have, if any, other than the ones I just mentioned downstream from that terminus point?
Sure, there's that's going to be covered in section 5 of the application, and there's a diagram in there, and it'll be testified here later when we get to that section. But generally speaking, there's a launcher receiver there, there's metering and measurement there as well, as I recall. But anyway, we'll get into the details of the system layout in section 5.
And is that one of the folks from EERC that'll be covering that?
It will be a person from EERC along with Jimmy Powell, our Chief Operating Officer.
Okay. And I see that you have positive manual shutoff valves, emergency shutoff valves, a blowdown, a pressure control valve, some check valves and block valves. Have you done any kind of modeling or investigation or research into the safety aspects of those valves and what happens with a valve failure?
Yeah, again, I'm going to defer those to Jimmy and the team that comes up here for that specific section.
If I have questions about performing LOPA or level of protection analysis or hazard operability study, would those also be questions for those same folks?
That's correct.
I have you go back up to section 3.9 of the storage agreement within the application. We were talking earlier about exhibits B and C to the storage agreement and the track participation factors. And I think I was asking if the participation factor was the percentage of acreage owned proportionately within the storage facility. Is that the proportionate acreage owned in that particular storage facility, being the Heinz or the Line Gang or the BK Fisher?
I believe I understood your question. I believe the answer is yes. That was a little long.
So in sections 3.7, 3.8, and 3.9 of the storage agreement, there's discussion of transfer of storage substances from one storage facility to another. And it says that this is allowed when the ownership between the storage facility and the transfer storage facility is common. What do you mean by, or what does this contract or storage agreement mean when it says the ownership between the storage facility and the transfer storage facility is common?
It's not intended to talk about a storage facility that is adjacent to each other. It is intended to talk about the storage facilities that may be in a stacked play.
Okay. Makes a lot more sense that way.
It does.
And so this provision doesn't or wouldn't have any applicability unless and until Summit were to permit an additional storage facility in a formation above or below the formation it's targeting with these proceedings.
That is correct.
Okay. Did any of the landowners attempt to limit the scope of their lease vertically based on the formation being targeted?
If you recall, that was a request that you made?
Okay. Did any other landowners make a request to limit vertically the scope of the lease with Summit?
No.
Okay. Do you have all of the agreements and rights under contract necessary for any surface facilities planned at present?
Yes.
There was some discussion earlier about the boundary lines for both the CO2 plume as well as the storage facility boundaries.
Mm-hmm.
Do you have an understanding of why the storage facility boundary is required to be drawn outside of the CO2 plume?
Yeah, it's my understanding of why the storage boundary is outside of the CO2 is so that, kind of per the requirements of the permit, we're required to operate within the boundary that we're permitted to operate in. Okay? And so we use the methodology described to determine a boundary. With the understanding there's 5-year review and renewal and adjustment, so we've identified the boundary, in our case, of outside of the post-injection stabilized plume area.
Is it your position or belief that the area of the reservoir in which you are operating is confined to the area of the reservoir into which you are physically injecting CO2 and it is existing in the reservoir thereafter?
Say that again so I understand, make sure I got the question.
Question, is it your position or belief that the area of the reservoir in which you are operating is confined to the area of the reservoir into which you are physically injecting CO2 and it is existing in the reservoir thereafter?
I don't think the question is clear. I think it's ambiguous. You aren't talking about whether you're talking about the aerial extent, you were talking about vertical. So I don't know that he can answer without you being specific.
Okay, well, let me just take another run at it.
And what I'm getting at is there's vertical limits and horizontal limits, and
Right.
we haven't defined. Perhaps you want him to answer both. I don't know.
Yeah, no, that's fair. So let's confine my question to vertically in between the confining layers as defined by the application. So when I'm talking about the reservoir for this question, it's in between the confining layers. And we'll call that the target reservoir. Is it your position or belief that Summit's operations are confined to that part of the target reservoir containing actual CO2 that was injected by Summit?
It's my understanding and belief that in our application, we're requesting a permit to store CO2 in this case, the Broom Creek Formation and the confining layers above and below. If that's what you mean by operations, is the storage of CO2, then I would say yes.
What else constitutes your operations other than the storage of CO2 downhole from the well injectors?
So we have, monitoring of various, reservoir formations, monitoring equipment along the well, monitoring of the plume using 3D seismic, for example, and so those are all parts of what I would say the operations is the monitoring of the activities as well, which we're monitoring outside of the storage horizon, so
Why are you monitoring outside of the storage horizon?
to confirm storage or permanence, if you will.
Are you monitoring anything other than the chemical makeup of the fluids in the reservoir or the target reservoir?
So we're going to get into that, extensively in the monitoring plan, of course. But, you know, we're monitoring, you know, water quality at various horizons, which will be identified in the monitoring plan. We're monitoring the plume movement over time, and that's covered in the monitoring plan as well.
How do
We're
you monitor?
Monitoring the well bore and doing inspections on the well bore, those kinds of things.
How do you monitor the movement of the plume?
We're proposing, again, in our monitoring plan, which we'll get into that in detail, but we're planning to monitor it incrementally using, or periodically using 3D seismic as our current proposal.
Does any of your monitoring look at the pressures in the formation?
Yes, there are pressure temperature sensors within the well bore.
Do you get data on temperature and pressure anywhere other than at the wellbore?
We will also get that in the deep subsurface monitoring wells, stratigraphic wells that are identified on, what is it, PS3 or 4?
How many of those do you have?
We have 3.
3 stratigraphic test wells.
Monitoring wells, yeah.
How many total monitors do you have for temperature and pressure within the reservoir?
So I'll defer that to the discussion on monitoring. But we have them on the stratigraphic wells, as I mentioned, the stratigraphic monitoring wells.
Why are you monitoring the temperature and pressures in the reservoir?
Again, I'm going to defer to the team that presents the monitoring plan to give you the specifics on the recommendations and why we're doing that.
Do you know what the Safe Drinking Water Act says about where to place the boundaries for your storage facility?
I do not specifically.
Do you think that the boundaries as defined by the Safe Drinking Water Act for the protection of freshwater aquifers is the same as the area within which you need to obtain property rights for your project?
Say that again.
Do you believe that the area required to be used for a storage facility in the Safe Drinking Water Act is the same as the area within which you need to acquire property rights for your project?
I would say I don't specifically know that.
Who would know that?
So if I can ask, are you asking if the Safe Water Drinking Act applies?
No. I'm asking if the boundaries required by the Safe Drinking Water Act are the same as the boundary around the property rights that you needed to acquire for your project.
We have another witness that we're going to call who'll be able to answer that question.
You guys don't know the answer?
Not sure I understand the question.
I have nothing further.
Any questions from the staff?
I'll jump in here first, just as a preamble before I start asking my questions, because we are listening to these as combined cases for all three applications. If I ask a question and it applies to all three, by all means, provide the answer for each individual one. I'll try to clarify if I think they're going to be a question that would be more consistent across all three or an individual question. And to start out, my questions here I'm going to be talking about are within the project summary section of the three applications. So in your exhibit 2A through 2C that you had provided showing the business structure for the three LLCs, I just want to have you clarify that when you have SCS Carbon Transport LLC listed as the flow line operator, that you are intending to mean that the three flow lines for these three facilities will be operated by SCS Carbon Transport LLC, but the ownership will still be under the individual Summit Carbon Storage LLCs. Is that correct?
That's correct.
You currently stated that you have 57 ethanol plants with contracts on. Is it fair to state at this time all of those ethanol plants are currently emitting all of their CO2 production that they make?
Yes, to the best of my knowledge.
How many miles of the MCE pipeline, the transmission pipeline, is within the PSC jurisdiction in North Dakota?
So there's, okay, you're asking how many miles within the,
Of the transmission pipeline, how many miles are in North Dakota that would be under PSC jurisdiction?
I'm going to defer to Jimmy on that question. My recollection is it's 352 miles. But again, that, I want to make sure that we get the right number. Oh, okay.
On page PS3 of all three applications, you report that the three storage facilities combined over a 20-year proposed injection period were modeled to be able to store approximately 352 million metric tons of carbon dioxide, which would be on average around 17.6 million metric tons a year. Additionally, later on that page, you state that the Midwest Carbon Express, the MCE transmission pipeline, is being designed to transport 18 million metric tons a year. Can you provide approximately how many metric tons you currently have contracts for?
Yes, a couple of things there. The current design of the MCE pipeline system is 18.5 million metric tons. With the 57 plants, we have approximately 16 million tons. Or they emit approximately 16 million tons that could be captured.
And as a follow-up to that, if you ended up getting to a point where you have contracts with a value that is up to what your current design is for the MCE pipeline, would you just be looking at additional storage facilities to be permitted to take on the additional capacity?
That's correct.
So those are the only questions I have for this group. Thank you.
I'm going to talk a little bit about section 1 of the pore space to start off with. And again, some of these answers may relate to SCS 2 and 3. Please answer for all of them if you can. Within the proposed storage facility area, shown, it's both figure 1.1 on page 1.2, or it's exhibit A, the track map of the storage agreement. In relation to that, has any pore space been severed from the surface estate since April 9, 2009?
No,
Is that the case for SCS 2 and 3, 1, 2, and 3?
that is the case for all 3 units.
Was any pore space leased from the surface owner prior to Summit leasing of the storage facility?
No, for all 3 units.
Is the storage facility and proposed well sites, testing and monitoring equipment, flow line located on or proposed to be located on any Indian lands, historic or archaeological sites?
No.
Okay. And is that for all of them?
Yes, for all 3.
Have you guys seen the written comments from the North Dakota State Historical Preservation Office that was sent on May 15th, 2024?
I have.
And do you intend to meet their requests?
We do.
Will the development or operations of the storage facility affect hydrocarbons, coal reserves, or any other potential mineral zones?
The next witness will handle that question.
Okay. I will defer, based on that answer, I will defer a couple of questions and go to a couple of errors we found on the land descriptions.
Okay.
They provided as part of the storage facility area a document called the Unit Legal Description for KJ Hints. We'll need an amended copy. The errors are in Township 142 North, Range 85 West, Section 7. It's listed as all of this section is within the storage facility area. This instead appears to be the west half and the west half of the northeast quarter, the northwest quarter of the southeast quarter, and the south half of the southeast quarter. Did you catch all that?
Do you have track numbers?
No, but we could pull them up. And then the second one is Township 142 North, Range 86 West, Section 25, where it states the east half of the northeast quarter. This instead appears to be the west half of the northeast quarter.
Understood?
And that is all for that section. Oh, no. Got a couple more. Are you finding that track?
I'll keep looking.
Okay. Now we'll move on to the storage agreement. And Article 1.1 defines carbon dioxide as including incidental associated substances, following the definition of carbon dioxide stream from North Dakota Administrative Code, Chapter 430501, in the Pore Space Lease Section 3. royalty, page D2, carbon dioxides, CO2 or carbon dioxide is called out. The question is payment based on the mass of the CO2 component of the stream only, or the full injection stream mass, including incidental?
I believe it is on the full stream, but there is someone better able to answer that question.
Okay. Can you briefly explain why you used the Milton Flemmer 1 as the type log in Article 1.15 for all three storage agreements?
We'll have another witness who can answer that question.
Okay. I think that, sorry, I'm moving to a different question based on your answer. I'm going to move to Article 5, track participations. In the storage agreement, you indicate that track participation is based 100% upon the ratio of surface acreage within the facility area. Can you explain the reasoning behind using land basis rather than pore volume?
Sure. We believe that using a track basis provides a equitable method for compensating all landowners based upon the life of the project.
In Article 8, we touched on some of these things earlier in cross-examination. Just a couple things I wanted to clarify, that this use of the activities this is going to cover includes like the location of monitoring equipment for soil gas, Fox Hills groundwater wells, and also any seismic equipment or activity.
That is correct.
Okay.
And for the commission's understanding, we'll continue to work as we have with willing landowners for every opportunity.
Okay. I think that's all I have for that section, or for you guys.
So just to jump in, for the two corrections, the first one was in track 23. The second one is track 56.
Thank you for that.
And is just one additional item in the storage agreement and the pore space lease agreement. There is a note, so in Article 1.15, you're currently defining the storage reservoir is including both the upper and lower confining zone in addition to the injection zone. And then in Article 3.6, where you talk about injection rights, it states the storage operator is granted to inject into the storage reservoir any storage substances in whatever amounts the storage operator may deem necessary. I just want to clarify again that the injection and storage of CO2 should only occur within the injection zone and not within the confining zones.
Yeah, understood.
Thank you.
All right, I'll try to bat clean up here. Couple things. First, there were a number of items that were discussed through the surface use agreement and the lease attached to Exhibit D as possible amendments to language within both. I guess at this time, I'm going to ask that whatever that amended language is proposed to be, that it be worked up and submitted as a supplemental. And that, I don't know if it's a complete list, but there was discussion on, so in the surface agreement, it would be 3.3, 2.4, 7.1, 10.2, and 8.1. And then I think 25 and 34 of Exhibit D is what I caught. I might have missed a couple.
Would you mind repeating that so I can cross-reference my notes?
All right, so I had notes on 3.3, so surface agreement, I'll start with surface agreement. 3.3, 2.4, 7.1, 10.2, and 8.1.
That matches.
And then in the Exhibit D, I had Article 24 and 34.
That matches my notes.
I'm also going to request, the court reporter is currently working up a transcript. I'm going to request that the transcript be provided as a supplemental exhibit after the hearing. Wade specifically, there was a fair amount of discussion as to the economics and the effect that this project would have on North Dakota economy. And per your preamble in the project summary on PS3, you indicate that the CO2 storage is critical to both agriculture and energy industries in North Dakota. Is it your intent at this time that the commission will make a determination with respect to 43050117 and the fees required for submission or for injection of CO2, and whether or not those fees shall be charged pursuant to Part A of that, or Part B, Part A being they contribute to the North Dakota energy or agricultural economies, and Part B, they don't? Is it your, so the question is, are you requesting that that determination be made as a part of this hearing?
Yeah, our request is that the commission make a determination on is Summit's project Part A or Part B.
And you understand that if the determination were to be that it did not contribute and it was subject to 1B, that we would need a supplemental, or not a supplement, a subsequent hearing to determine what those fees should be set at.
I do understand that, yes.
With respect to that request, I'm going to ask for another supplement of what you provided as Exhibit 3A, identifying, I guess, each of the capture facilities that you have identified there and where their locations are. It's probably sufficient just to indicate which states they're in, or just number them and give us a name so we can determine whether or not they're, or where exactly they are.
Understood.
With respect to the cases on the docket for the establishment of the pool and field boundaries associated with these facilities, does Summit have any opposition or any concern if the field boundaries are established as the facility area boundaries, and the storage reservoir or pool defined in those would be equivalent to the storage area as proposed in the surface use agreement?
No.
I'm going to ask this here, though it may be appropriate for another witness. On your figure 1.1, page 1.2, this is the map illustrating the pore space. Looking at section 35 in 14188. It would look like the plume boundary is almost equivalent, if not at the exact same point as the storage facility boundary. The line appears to be at the same spot.
So can you say the diagram you're looking at again?
So figure 1.1, it's on page 1.2 of the application.
Okay, yes, I have it now.
And again, so Township 141, Range 88, Section 35. There's a little portion of the identified stabilized CO2 plume extent that is at the same point as the storage facility area, at the line that the storage facility area identifies. So it looks like there's no buffer there. Is that intentional, or is that something that should be directed at another witness?
Yeah, we have another witness that could testify to the specifics, but there is a buffer there.
Okay.
Right.
Do you know what that buffer is?
We'll have another witness testify exactly the buffer.
And would the other witness also be the person to direct the odd shape of the plume? So when I say the odd shape of the plume, there's a little carve out in the middle. It looks like no CO2 is going to affect that central area.
Yes, I think we'll defer that to the next section
Next
here
group.
in geologic modeling and simulations to answer that.
Okay. There was a fair bit of discussion on Section 8 of the storage agreement. And I just want to point out that, I guess, there's a Article 8.3 within there indicates that the damages will be paid to any surface owners disturbed at the surface. Is that correct?
That is correct.
One minor typo in the surface use agreement, Article 15.1. I believe the title of that section should be bolded and underlined.
Term?
Yep, single word. Article 16.2 on page 15 of the storage agreement. I'm not a lawyer, so I'm just looking for what this language means. The joinder and dual capacity language here, I don't really want to quote it at you, I think you can read it yourself, but what is the intent of that article, and specifically with respect to the "and any additional interest thereafter acquired" language?
You want me to take a crack at it?
I don't care who answers
You don't have
it.
any objection? If there were a situation where the operator, Summit, who is the operator in this, also owned an interest in the pore space by executing the storage agreement, they'd be executing basically as both parties, both as a operator and as an owner of the pore space.
So with that explanation, it would have nothing to do with anything that a landowner acquired after the point at which they executed?
I don't believe so. It would be, it would apply to a situation, though, if Summit were to sign this as a joint owner and then acquired additional surface interests, that surface interest would then be basically agreed upon with this language. If that's something I don't know that it's certainly not necessary in this agreement. So it's something that I can speak with my clients and see if we can't get it resolved.
Okay, I'll add that to the list of supplemental language adjustments.
6.2, 16.2.
all I've got. Thank you.
Just a couple of quick questions, Jeff, on Exhibit 5A. If you go to page B3, be as good as any.
And what page was that?
B3. On the very right column, there's blank columns, and we'll look at track number 8. In the life estate, those columns are filled out all the way across. And then there's 4 blank ones there. What's the meaning of that, those interests or whatever they are with basically zero participation?
Sure. So as you look specifically on page B3, track number 8, Joanne Skalski owns a life estate. The parties listed below her are the remaindermen, such that upon her death, they gain the interest in the property.
Okay,
And so we joined them in our pore space lease because they own a future interest.
okay. And then with your no surface facility, no surface occupancy discussion, and any amendments that may take place with that, would it be your intent that that language would not preclude Summit from conducting future seismic operations?
That is correct. It is in no surface facilities.
Okay, thank you.
Apologies, I do have 2 more things to address. There was a fair bit of discussion about the NAICS codes, industrial codes. The provision in the rules 43050107, it's part 3C, indicates that 4 standard industrial classification codes which best reflect the principal products or services provided by the facility shall be provided as part of the application. To date, the codes that have been provided for other facilities have listed either the ethanol facility, that have been related to the ethanol facility that was being used, or the industrial entity as the source of the CO2. In the case of DGC, I don't recall what it was, but it was related to the Synfuels plant. The code you provided would indicate it was pipeline related as the source of the CO2 as far as the sequestration facilities were concerned. Do you have the code, or do you know what it is, or can you supply it for ethanol facilities as the source of the CO2?
We could supply it. I don't have it.
We'll probably request that if another witness doesn't have it available. We'll request that that probably be provided, as well as the potential, well, at this time, you're not including the alternate source of the CO2 as the,
Mr. Suggs, one of our witnesses is going to talk about Section 12 in the application, and he would be the witness to address the question about the codes.
okay. That's fine. We'll hit it there then. And then one more, I guess, piece of clarification. When you were being questioned, Wade, regarding the model and what was submitted to the commission, you indicated that the model had been submitted to the commission, the whole model. Point of just clarification, what is submitted to the commission is the numerical simulation in the GEM software, which includes the model as it was imported from the geologic model that the EERC developed in Petrel, sorry. So we don't have the whole geologic model. What we have is the version of it that comes in through the numerical simulation. So just a point of clarification on that testimony.
Yeah, that's my understanding as well. And certainly Amanda can testify more specifics as needed related to what was submitted to the DMR and that relate.
And that's all I've got. Thank you.
Any redirect, Attorney Bender?
No redirect.
Okay, call your next witness.
Okay. We'll be calling Amanda Douglas and Caitlin Olson. What's that?
You want to leave all these here?
I think I got everything on these. I don't think I gave you any of mine, so I think I got everything. This stays. Again, maybe you should read those in case I'm sure that gets asked. Good point. And then let's do- Why don't we just close this and then we'll put them on top.
What were the tracks that were the mistakes?
Okay, Ms. Douglas, please raise your right hand. Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Amanda, state your full name for the record, please.
Amanda Jordan Douglas. I'd just like to note that I do go by Amanda Livers Douglas, so you might hear that as well today.
And Amanda, by whom are you employed?
The Energy and Environmental Research Center at the University of North Dakota.
In what capacity?
So I'm an assistant director for integrated subsurface projects.
Can you explain just very briefly what that title includes in terms of your role with EERC?
Yes, so I oversee and manage the collection of geophysical and geologic characterization data. I also manage and serve as an advisor on commercial carbon capture and storage development projects. I also oversee and manage a team of geoscientists, including 10 geologic modelers.
Okay, and I'd like you to highlight for us your educational background and work experience.
I have a bachelor's in physics from Concordia College in Moorhead, Minnesota, and I have a master's in geology from the University of Kansas. My work experience includes 3 years as a graduate research assistant at the Kansas Geological Survey, where I worked on a professional seismic crew, and 8 years of employment at the EERC.
Amanda, what are some of your duties and responsibilities with respect to your employment with EERC generally and specifically with respect to the project that's before us today, or projects?
So as previously stated, my roles at the ERC, with respect to this project in particular, I oversaw the development of several sections of the storage facility permit application. I also advised on data collection as well as geologic modeling and simulations.
And it's my understanding that you had direct involvement in sections 2 and 3 as well as Appendix C, is that correct?
That's correct.
Okay, let's turn your attention to sections 2 and 3 of the application. Can you provide us with a brief overview of what your testimony will cover?
Yes, so I'll be providing a high-level overview of the key takeaways from Section 2, 3, and the associated appendices, which are Appendix A and C.
Okay, and Wade provided us with sort of a high-level overview of the project. What I'd like you to do is provide the commission with a more detailed overview of the project.
Okay?
You'll do that?
Yep.
Okay, okay, let's start. How was the project area selected?
So as Wade previously testified to, there are several factors with respect to the technical considerations related to the suitability of the geology for determining the site location. Previous state and federal funded projects suggested that this region of North Dakota has suitable geology for CO2 storage. Through this project, acquisition of site-specific data confirmed the viability of the subsurface geology for safe and permanent storage of CO2.
Can you explain for the commission staff and opposing counsel why the Broom Creek Formation in this area is a good candidate for CO2 storage?
Yes. So the Broom Creek in this area has sufficient thickness and porosity and permeability for the injection and storage of large volumes of CO2. It's also at a depth at which CO2 would stay in supercritical state, which is conducive for the efficient use of pore space. I'd also like to point to figure 2-9 on page 2-16. So this is a map of the extent of the Broom Creek Formation in North Dakota, showing that the Broom Creek is laterally extensive across this project site. The Broom Creek is also overlain by an upper confining zone that is devoid of transmissive faults and fractures with sufficient vertical extent and permeability to serve as fluid migration pathways. And that upper confining zone is laterally continuous over the storage facility areas.
Amanda, now I'd like you to discuss a bit the confining zones of the Broom Creek Formation. You explained for us why the Broom Creek Formation was selected from the standpoint of it being prevalent in the area. Can you now discuss for us the confining zones above and below the Broom Creek?
Yes, so the upper confining zone is considered to be all of the formations from the top of the Spearfish Formation down to the top of the Broom Creek Formation. And so I'd like to point you guys to page 2-19. So we're showing on figure 2-11 a well log display, and I'd just like to point you to the upper confining zone, which is labeled as the Opeechee/Spearfish. So this is log data from the Milton Flemmer 1 well. And so at the Milton Flemmer 1 well, the upper confining zone consists of the Spearfish, Minnetonka, and the Opeechee. The Minnetonka is typically used to differentiate between the Spearfish and the Opeechee. At the Milton Flemmer well, the Minnetonka is approximately 23 feet thick, but the Minnetonka pinches out. And so that's why we'll refer to the upper confining zone here as the Opeechee/Spearfish, because in most places for this specific storage facility area and the other two storage facility areas, the Opeechee/Spearfish is undifferentiated due to the absence of the Minnetonka.
Now, what properties in the upper confining zone that you just discussed make it a good seal?
So the upper confining zone has a low permeability and porosity. It also has a high relative permeability, a high capillary entry pressure relative to the injection zone. It is devoid, as I mentioned, of faults and fractures with sufficient permeability and vertical extent to act as a fluid migration pathway, and it's laterally extensive across the storage facility areas.
And what data did you use to validate suitability of the storage complex for CO2 injection and long-term storage?
So I'm going to point you to the two maps on page 2-5 and 2-6, which is figure 2-3 and figure 2-4. So these maps are showing the data used for our evaluation as well as the construction of the geologic model. So this includes 2D and 3D seismic data. It includes site-specific well log, core, fluid sampling and formation testing data, as well as regional logs, core, fluid samples, and formation testing data.
And Amanda, what are the mechanisms for geologic confinement?
So initially, as after the CO2 is injected, it will be contained by the upper confining zone itself. So the CO2 is a buoyant fluid, and it will be contained under the effects of relative permeability. So laterally, the CO2 will be contained via residual gas trapping, and as CO2 dissolves in the formation brine, it will be confined through solubility trapping. As mentioned, after this, as the CO2 dissolves, the brine it dissolves into will become more dense, and that will eventually sink lower in the Broom Creek Formation. And over a much longer period of time, hundreds of years, mineralization will start to occur, and that will also become a trapping mechanism.
Amanda, in your expert opinion, will geochemical interaction impact seal integrity or injectivity?
So no geochemical interactions of the injected CO2 with the upper confining zone will not impact integrity of the confining zone. So we did an analysis using geochemical modeling. So the upper confining zones, as I mentioned, are low porosity and low permeability. We don't expect the CO2 to have much interaction with the upper confining zone, but we wanted to look at an extreme case or a conservative case. What would happen if the CO2 did have interactions with the upper confining zone? Would there be any adverse geochemical reactions that would impact the ability of the confining zone to contain the CO2? So what we did is we used a software called FreakC to do modeling of the upper confining zone. So the FreakC software doesn't, it uses a transport mechanism of dispersion to allow CO2 to flow through the model cells. It doesn't use permeability to dictate flow in the model. And so this is a conservative case where we're able to expose the model cells to that CO2. So to populate the model, we used site-specific geochemical analysis of fluids, of mineralogy from the core data, and CO2 composition. So it should be noted for the CO2 composition, we also took a conservative approach where we modeled a CO2 stream of 95% CO2 and 2% oxygen. So this is more oxygen, higher oxygen amount than is in the anticipated CO2 stream as Wade testified to earlier. We chose to use this composition for modeling as oxygen is known to be more reactive, and so we wanted to look at an extreme case. And even in this extreme case where we're ignoring permeability, we're allowing CO2 to contact the upper confining zone, we're using a CO2 composition with higher O2. The modeling demonstrated that interaction with the CO2 to the upper confining zone would result in no adverse effects. So there is little to no porosity change due to precipitation or dissolution from the model. Additionally, sorry.
No, you're fine.
Additionally, related to injection, we also did geochemical modeling of the injection reservoir using CMG's GEM software, where we simulated CO2 injection into the reservoir, again using that 95% CO2 and 2% oxygen case. And we saw similarly little to no effect on porosity due to precipitation or dissolution of minerals due to the interaction of the CO2. So we don't anticipate geochemical reactions will impact injectivity adversely.
Okay, when the two previous witnesses were up here testifying, there were some questions about what sort of impact injection could have on underground sources of drinking water. In your expert opinion, will there be any adverse effects?
No, there will be no adverse effects on underground sources of drinking water. As I previously mentioned, the Broom Creek is overlain by a competent confining zone that is devoid of transmissive faults and fractures that could serve as fluid migration pathways. I'd also like to note that above that primary confining zone, there's approximately 1,000 feet of additional low permeability rock that will contain the CO2. In addition to that 1,000 feet, there's another 2,000 plus feet of impermeable rock below the lowest USDW, which we're defining as the Fox Hills Formation.
Now, you indicated that there was no evidence of fluid migration pathways. How did you determine an absence of fluid migration pathways?
So we looked at several data sets, including 3D seismic data. We looked at formation image logs in terms of fracture analysis. We also did fracture analysis of the whole core that was collected from the project. Additionally, we looked at fluid samples to evaluate if the Broom Creek Formation was hydraulically isolated from the next porous and permeable zone, which is the Inyankara Formation.
Let's talk a little bit about seismicity. In your expert opinion, is there a risk that seismicity will interfere with the containment of the CO2?
There is little risk that seismicity will interfere with containment of CO2. So I'm referring to both naturally and induced seismicity. So there's a lack of historical earthquakes in North Dakota. We've looked at historical earthquake data. Just one study in the permit that references this is a study done by Anderson and others in 2016 on page 269, figure 2-44, shows the dots on this map reflect the historical earthquakes from the late 1800s to 2015. And there's fewer than 20 historical earthquakes during this time frame. And so this can be attributed to the general geologic stability of the formation. So in addition to this stability of the region, we'll be operating the project under the fracture pressure gradient of the Broom Creek Formation, which is also lower than the fracture pressure gradient of the upper confining zone, which reduces risk of induced seismicity.
Now, Commission staff had some questions of the past two witnesses about commercially valuable minerals. Do any of the three proposed storage facilities contain commercially valuable minerals?
Yes, so there is lignite coal reserves within each storage facility.
And are there any oil-bearing formations or other hydrocarbons reserves located within the boundaries of the storage facilities?
So the North Dakota Geological Survey recognizes the Spearfish Formation as the only hydrocarbon-bearing formation above the Broom Creek Formation, and that is devoid of hydrocarbons in the project area. We've also found no evidence of hydrocarbons in formations below the Broom Creek Formation or within the Broom Creek Formation. We evaluated this through review of legacy well bores, existing oil and gas exploration studies, historical production data, which are discussed in the permit, as well as evaluation of the mud logs for the 3 stratigraphic test wells.
What if hydrocarbons were ultimately discovered within the storage facility area? Is there some way to develop those hydrocarbons?
Yes, so engineering controls could be used to produce hydrocarbons located below the injected CO2 at each storage facility area. These may include, increased mud weight to account for increased pressure in the reservoir due to injection. Also, you could potentially drill horizontally underneath the plume to produce any potential hydrocarbons that are discovered in the future.
And directionally as well, is that correct?
Yep.
Okay. I don't know if you covered this, so I'm going to go back to it just for a moment. I think you indicated that there were some reclaimed coal mines in the area. Are there any plans to mine any coal that's in the area?
So there's a map on page 277. It's figure 2-51. 2-51 is showing the future and reclaimed mining areas for the Coyote Creek and the Beulah mine. So those are the 2 mines closest to the 3 storage facility areas. So within the storage facility areas themselves, there is no currently, there's no future mining plans from either of these wells. Additionally, operation of the storage facility area wouldn't preclude future production of the coal, And the areas where there's surface facilities for this project, there are no active coal leases that are known.
And since the storage zone is quite a bit deeper than the coal in this area, is it a possibility of mining the coal even though you have a storage facility in place?
Yes.
Okay, let's switch now to section 3 of the application. And can you briefly provide an explanation of which permit requirements are addressed in section 3?
Yes, so Section 3 provides an overview of the geologic modeling and dynamic reservoir simulation activities that were conducted to define the vertical and lateral extents and migration of injected CO2, as well as the associated pressure front, the stabilized CO2 plume, and the area of review.
And can you talk a little bit about the geologic modeling activities that were conducted with respect to these 3 applications?
So geologic modeling was conducted using industry standard methods and Petrel software. So this included the evaluation of geologic data, the construction of a structural framework, and distribution of rock and petrophysical properties.
How was the geologic model utilized to address the permit requirements?
The geologic model served as inputs for the dynamic reservoir simulations. So the dynamic reservoir simulations were done using industry standard methods and CMG software. As mentioned, dynamic reservoir simulations were conducted to determine the lateral and vertical extents of the injected CO2 to define the project boundaries.
And how was the area of review delineated?
The area of review was delineated using a risk-based approach developed by the ERC and published in Matt Burton Kelly 2021.
Amanda, before I get to the statutory questions, there were some questions about previously filed information that ultimately resulted in what I'm going to call the final form of the application. Can you just enlighten us as to when you started working on this project, when you started filing things with the commission, and give us a little bit of an idea of what you filed?
Previously, or
Yep.
the final form?
Yep.
So ERC was submitted a contract to Summit, I believe Wade mentioned in early 2020. We began work on collecting the site-specific data. We helped prepare permit applications, and we submitted draft permit applications to the DMR, I believe, late spring, early summer of 2023.
And there was some discussion about some of the data that was submitted, and the modeling that was done. Can you describe just a little bit of that and what was submitted to the commission in terms of the data and providing the commission an opportunity to review that data and do simulations?
Yep, so as requested by the DMR, we supplied all the shape files associated with the project. We also provided the geologic model in the form of the output that was used for dynamic reservoir simulations.
And is it your understanding that all that information that was submitted to the commission was available to the public?
Yes, and in addition to that, the majority of the input data for the model is publicly available. A lot of the data, or majority of the data used in the geologic model can be found on the NDIC's website, which included, core data, well logs, fluid sample analysis, as well as formation tests.
Okay. Now, the statutory questions. In your opinion, Amanda, is the storage facility suitable and feasible for carbon dioxide injection and storage?
Yes, as I previously mentioned, the Broom Creek Formation has characteristics that are conducive for geologic storage of CO2, including being overlain by a competent confining zone.
And in your opinion, is the carbon dioxide to be stored of a quality that allows it to be safely and efficiently stored in the storage reservoir?
Yes, so we conducted geochemical modeling that demonstrated that the anticipated CO2 stream will not have adverse geochemical interactions on the upper confining zone.
And in your opinion, will substances that compromise the integrity of the storage reservoir, will they not enter the storage reservoir?
Yes, so the anticipated CO2 stream to be used for the project is not anticipated to have adverse impact due to geochemical interactions.
Okay, and to get a conclusion from you with respect to some of the things you discussed having to do with minerals in the area, do the storage facilities contain commercially valuable minerals?
Yes, as previously mentioned, all 3 storage facilities contain lignite coal reserves.
And as you testified previously, that doesn't prohibit, that this storage facility or these storage facilities won't prohibit the mining of that coal if it's economically possible to do so. Is that correct?
Yes, that's correct.
Okay. In your opinion, will issuance of a storage facility permit adversely affect mineral owners or mineral lessees?
No, as previously stated, if there's hydrocarbon reserves discovered in the future, there's engineering controls and other methods for the extraction of those minerals.
And in your opinion, can the proposed storage facility be operated in a manner that will not adversely affect surface waters or formations containing fresh water?
Yes, so as mentioned, the storage formation is overlined by a competent upper confining zone that's devoid of transmissive faults and fractures with sufficient permeability and vertical extent that could act as a fluid migration pathway.
And you touched on this on your testimony, but just a question to confirm, in your opinion, can the proposed storage facility be operated so that carbon dioxide will not escape from the storage reservoir?
Yes, as mentioned, it's the storage reservoir is overlain by a competent upper confining zone that is devoid of potential fluid migration pathways.
And based on your study and review of the testimony and exhibits that you've testified here today and your knowledge of the project as a whole, in your expert opinion, are the horizontal and vertical boundaries of the storage reservoir adequately defined and include buffer areas to ensure that the storage facility is operated safely?
Yes, geologic modeling and dynamic reservoir simulations were used to define the vertical and horizontal boundaries of the storage facility area, and the storage facility area includes appropriate buffer.
That's all the questions I have for this witness. We'd like to move to Caitlin Olson, if we may.
Ms. Olson, please raise your right hand. Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter will be true and correct to the best of your knowledge and belief?
I do.
Caitlin, can you state your full name for the record, please?
Caitlin Olson,
And Caitlin, by whom are you employed?
the Energy and Environmental Research Center.
In what capacity?
I am a principal policy and regulatory strategist.
And like Amanda did, what I'd like you to do is briefly highlight for us your educational background and work experience.
I graduated with a Bachelor's of Science degree in geology with an emphasis in hydrogeology from the University of Wisconsin-River Falls. I started work for the Department of Mineral Resources, where I started as a petroleum engineer field inspector. I ended here with the Department of Mineral Resources as a production supervisor. In 2022, I held those positions for 8 years, and then in 2022, I started working for the EERC, where my position was a senior regulatory and permitting specialist. My position today with the EERC is a principal policy and regulatory strategist.
Caitlin, what I'd like you now to discuss for us is what some of your duties and responsibilities are with respect to your employment with the EERC generally, and specifically with respect to the projects that are before the commission today.
Sure. So generally, I oversee commercial
CO2 storage projects and the development of their permits. I also work in oil and gas regulations and provide policy advisement there. Specific to this storage facility permit, I oversaw the creation of the storage facility permit and compliance with regulations.
Okay. So Amanda spent some time discussing sections 2 and 3 in the application. Let me direct your attention to section 4 of the applications. Can you briefly explain how the AOR was used to evaluate the region and to meet specific permit requirements?
Sure. The area of review, as you'll see on page 4-1, is defined as the region surrounding the geologic storage project where underground sources of drinking water may be endangered. The AOR in this case contains the storage facility area boundary, and that is based on the simulation extent of the stabilized plume, and includes a 1 mile buffer outside of the storage facility area to encompass the entire area of review.
So can you direct your attention to the map in the application that depicts the AOR? And give everyone a little time to get there.
If you'll look at figure 4-3, that map shows the area of review on the outside in purple. In farther is the storage facility area denoted as a black line, and even farther is the stabilized CO2 plume extent. Within this map, you'll see groundwater wells and 1 spring. You'll see the stratigraphic reservoir monitoring well, the Milton Plummer 1. You'll see the 2 proposed injection wells, and if there were legacy oil and gas wells present, they would be shown here, but there are no legacy oil and gas wells present in this particular permit.
So Caitlin, after you identified the AOR, what type of evaluation was conducted by you and other staff members of EERC?
A review of data of public record was performed, where for all wells within the storage facility area and the AOR itself. And included in that review was any wells that penetrate the overlying seal, the OPG spearfish formation, and any other wells that might exist in the area of review.
So the first step of evaluating the AOR is you look for any wells that are drilled in the area, is that correct?
That's correct.
Okay, and then did you identify any wells?
We did. There's one particular well only one well in this area of review that penetrates the upper confining seal, the OPG spearfish formation. And that well is described as the Milton Plummer 1, which was drilled specifically for this project as a stratigraphic test well and as the monitoring well. Figure 4-4 further explains the Milton Plummer 1 and how it's constructed. So the Milton Plummer 1, during this review process by a geologist and an engineer, was found to be properly isolated, which prevents the migration of any fluids into USDWs, and a determination was made that no corrective action is needed for this well.
Now, Caitlin, it's my understanding that a reevaluation of the AOR and corrective action plan period is proposed not to exceed 5 years. In your opinion, what would trigger reevaluation prior to the 5 years, and what sort of reevaluation would that address?
Yeah, so Summit will comply with North Dakota rules, which is to reevaluate the storage facility area every 5 years. Any triggers prior to that 5 years where Summit would be required to reevaluate the area review and storage facility area would be if monitoring and operational data requires it, or if there's a significant enough change found in the area of review that would warrant it.
If there were significant changes, what would happen next, in your opinion?
Summit would update the model using history match data or the site-specific data that they've found through injection activities. And then based on that updated model, would work with the DMR to perform any corrective action if required or if needed.
Now, in addition to the matters that were discussed by Amanda with respect to confining zones, what other information and data was used to assess protection of underground sources of drinking water within the AOR?
So aside from looking at the DMR database for the Milton Plummer 1 well and using Summit's own records. Sorry. Okay, sorry. Alongside using Summit's records and DMR records for the Milton Plummer 1 stratigraphic test well, other data sources were used. Those data sources to review these wells within the area of review include the USGS database, the US Geological Survey database, the Public Service Commission, and the Department of Water Resources.
And did you examine freshwater zones?
We did.
Can you explain to us what the lowest freshwater zone was that you examined?
So described on page 4-12, the lowest USDW in the AOR is the Fox Hills Formation. And together, that comprises, includes the Hell Creek Formation to comprise the confined aquifer system that includes both. The Fox Hills Formation in the AOR is about 1,500 feet deep here and is about 250 to 300 feet thick.
Are there any Fox Hills wells in the AOR?
There is one Fox Hills well existing in the area of review. That's included in a map on the next page. Nope. On figure 4-10 on page 4-17. That well is included to be in the testing and monitoring plan during the life of the Summit project and is included in the baseline testing and monitoring plan.
So other than the Fox Hills, did you look at any other freshwater zones?
Yes, so Summit worked with landowners in the area to identify any other potential freshwater zones above the Fox Hills where testing could be performed. They ground truthed the area based on the groundwater well maps that you'll see in figure 4-3. And during those ground truthing efforts and based on depth of wells, a final determination of the baseline testing and monitoring plan with respect to groundwater monitoring and the life of the injection project groundwater monitoring plan was determined. And the final wells to be included is shown on figure 4-10.
So other than what you've discussed so far, what additional protections are in place or will be in place for underground sources of drinking water?
There are multiple impermeable layers throughout this area. So as Amanda testified to, directly above the Broom Creek is the O-Pee-Chee Spearfish Formation. And then directly below the Fox Hills Formation is the Pierre Shale, which is an impermeable a shale that provides the protection directly beneath the Fox Hills Formation. And in between those two impermeable layers are other multiple confining layers that provide protection to USDWs.
Caitlin, in your expert opinion, can the storage facility be operated so that it will not endanger human health nor unduly endanger the environment?
Yes, engineering safeguards are in place, and the site consists of ideal geologic confinement and geologic mechanisms that will protect human health and the environment from any CO2 injection activity.
No further questions of Ms. Olson.
Mr. Broughton?
Thank you, Your Honor. Is there lower porosity in the lower confining zone than the upper confining zone?
So table 2-7B on page 2-32 contains ranges for permeability as well as averages from core analysis as well as the simulation model with respect to the Amsden formation. Typically, the Opeechee spearfish, which is the upper confining zone, has lower permeability than the Amsden formation, which is the lower confining zone.
You discussed the Fox Hills freshwater aquifer. Is that the only freshwater aquifer that you studied with respect to the application?
No, as Caitlin mentioned, we identified several other freshwater aquifers in the project area. Additionally, point you to Appendix B, which includes some of the fluid sample analysis. So one of the other horizon sample listed on page B1 includes the Tongue River.
Do you have a depth for where that sample came from?
I don't have one in front of me at this time.
Is do you know whether the Mission Canyon or Lodge Pole or anything in the Minnelusa group contains a freshwater aquifer within North Dakota? As defined by the Safe Drinking Water Act?
Are you asking if those are USDWs?
Correct.
The lowermost USDW is the Fox Hills Formation. So nothing below that would be considered a USDW.
Based on the criteria in the Safe Drinking Water Act or just classification?
Yeah, based on, I mean, what specifically in the Safe Water Drinking Act are you referring to?
Does it, are these freshwater aquifers pursuant to the criteria for a U.S. drinking water in the Safe Drinking Water Act?
I can't speak to the entirety of the Williston Basin or North Dakota, but within the storage facility area, I do not believe that they are below 10,000 parts per million.
How does the permeability of the spearfish or the other impermeable zones compare to the Bakken or the Three Forks?
I don't have data from those formations on hand.
Do you know how it compares generally, though?
Objection, relevance.
Overruled.
I'd say it's comparable.
Did you take any water samples from any areas within the Minnelusa group or the Madison group?
We did not. I'm basing that answer on regional salinity maps.
And based on regional salinity maps, those, you're saying the total dissolved solids for those are above the thresholds in the Safe Drinking Water Act? Or below?
Above, so they're above 10,000 part per million.
Do you know what they are?
I don't have those maps on hand, no.
Do you know if they're between 10 and 15,000?
I don't know that.
Where would that information be contained?
Several of those maps can be found publicly available. I believe the North Dakota Geological Survey has published some of those online.
Do you know whether, well, do you know for certain whether the total dissolved solids in any of those, in any of the water in those formations? Let me start over. With respect to any waters in the Minnelusa group or the Madison group, do you know sitting here today that they are below 10,000 total dissolved solids?
I do not know that. We did not sample that as part of this data characterization plan. Regarding potential leakage pathways from the storage reservoir into those zones, the Amsden is also devoid of transmissive faults and fractures that have sufficient vertical extent of permeability for CO2 to leak from the Amsden into lower formations.
Would you make any suggestions on alternative ways to conduct operations here if you discovered that there was a U.S. drinking water and a freshwater aquifer under the Safe Drinking Water Act in the Minnelusa Madison group?
So for the operation, we'd potentially want to add additional monitoring of those zones as well. But I don't believe the injection operations, in my opinion, I would not recommend any changes to injection operations besides additional monitoring.
And when you say you wouldn't recommend any changes to injection operations, are you referring primarily to the injection pressures and the max pressure of injection?
Correct. And targeting the Broom Creek itself for injection. Could you clarify your earlier question? You talked about the Madison group. Did you also mention the Minnelusa group?
I did.
So the Broom Creek itself is within the Minnelusa group, and so we've sampled that, and it is over 10,000 parts per million.
And that sample was from above the Amsden Formation?
Correct.
So as part of developing this application, you ran a model in the Petrel software?
I personally did not, but the ERC team did, yes.
Okay. And ran a model in the GEM software?
So I'd say we constructed the model in Petrel software, and then we used it to run dynamic reservoir simulations in CMG.
And you also use the Freak-C model for the geochemical interaction modeling?
That's correct.
And did you submit the data decks for each of those three models to the Oil and Gas Division?
So all of the data that was used is either described in the permit was provided the DMR or is publicly available outside of the seismic data.
Did you say that all of the data provided to the DMR is what is in the permit application? No, okay, I misheard that. Did you, EERC, provide the data decks for those 3 models to the Oil and Gas Division?
Can you define data decks?
What do you understand a data deck to be?
So the raw data we used is publicly available. Any assumptions used have been detailed in the permit. For example, geochemical modeling, we list the mineralogy from the specific sample that was used. We listed the CO2 composition. We listed some of the additional other input data, including, just 1 second. Including parameters such as exposure level and things like that. So we believe that in the case of the geochemical modeling, they would have all the information they would need to evaluate or replicate the modeling.
You say they would have all the data they need to replicate the modeling. Who's they?
The DMR. In the case of the geochemical modeling, all the information is publicly available, so anyone could potentially replicate these results.
Is your education and professional background in geology or engineering or both?
So I have a master's in geology with an emphasis in geophysics, and I have a bachelor's in physics.
Okay. Do you ever talk to coworkers and other colleagues about the models that we just discussed?
That's correct. So as I mentioned earlier, I actually oversee the ERC's geologic modeling team.
And have you ever heard someone at EERC use the phrase data deck?
No, we don't use that term.
Have you ever heard anyone doing petroleum reservoir engineering use the term data deck?
The term is familiar.
Do you know what a data deck is?
I think the definition's subjective.
Is the well testing data that you used to tune and develop the permeability model publicly available?
The well testing data from the Milton Flemmer 1 well is publicly available on the NDIC website, yes.
The .dat file?
I'm uncertain of the format that's online.
What would you do with a PDF file with that information? It's not really usable, right?
Depending if it's in tabular or table format or if it's graphical.
You know what, now's a good time to take a last 10-minute break, then we'll come back and finish on up.
Okay.
We are back on the record. Attorney Broughton, you were questioning Summit's witnesses.
Thank you, Your Honor. You said that the data to run your geologic model was publicly available, right?
Everything except the 3D seismic and interpreted volumes from the 3D seismic.
Can you do it without the 3D seismic?
Can we replicate the exact model?
Right.
Actually, let me correct that. So based on what's in the permit, yes, because with the 3D seismic, we used the seismic to interpret varigrams, and the variogram lengths interpreted from the seismic were listed here. The one thing you might not be able to replicate is that we use interpreted seismic horizons from the seismic data for the structural model, so that would not be duplicatable without the 3D seismic.
If you were asked to analyze the models that you created here as a third party, and given the data you're saying is publicly available, but knowing nothing about the project going in, how long would it take you by yourself to replicate these models by going through all of the publicly available data and reconstructing it, collating it, organizing it, choosing it, picking your tops? How long would it take you to recreate that model?
Typically, our modeling workflow for a model of this size and scale with this amount of data would be approximately 6 to 8 weeks to go through that process. Keeping in mind with the formation tops, there are publicly available formation tops out there. It's a matter of QCing them.
Is that what you did?
Yes.
But you chose the formation tops used in your model, right?
So we went through the publicly available ones and quality controlled them.
How'd you do that?
So our method is based on core analysis. So we also looked at core analysis to determine where we thought the top of the Broom Creek was. And so we've reported in the permit how we picked the top of the Broom Creek. So if someone wanted to pick how we picked it, we report where we pick it on gamma ray log signatures. That's in the permit. And so we evaluate whether the publicly available picks match that specific signature in the logs to determine if we're going to use that top or adjust it.
Without the impedance data, you could not recreate the model to the same degree of accuracy as you did, right?
The models would be different.
And you said if you had to start from scratch knowing nothing, you think you could get it done in, was it 6 to 8 weeks?
6 to 8 weeks with the with what's published in the permit and the publicly available data. I think what's published in the permit provides a lot of time savings.
And is that time estimate for you and your team to do that?
If we were to replicate this with all the things in the permit, it'd be significantly quicker.
Meaning it would be quicker if you had your whole team doing it?
No, quicker if we're replicating using the assumptions, using the variogram lengths that we report and stuff like that, because we're not interpreting the data to come up with new variogram lengths. So if we wanted to replicate the model using the permit, what's in the permit, and the publicly available data, it'd be considerably faster than 6 to 8 weeks.
And again, is that for you and your team to do that?
That would be for 1 or 2 individuals, correct?
Working full-time,
Yes,
all day, every day?
8 hours a day.
If we didn't have the impedance data, how would the model be different?
So as I mentioned, the main difference would be the structural surfaces. So your structural surfaces would be confined with your well control. So there'd be slight variations on the structure of the formations. Petrophysical property distribution might be slightly different as well.
Different meaning less accurate.
Is your, so there's,
It results in a less predictive model.
Which question you wanted to answer?
Well, I was clarifying my prior one.
Okay.
so I'd say the models are different. I think it's subjective how you define model accuracy.
But if we define it as how predictive it is, it would be less predictive if we didn't have the impedance data.
It would have potentially less detail in it.
Are you familiar with the Freak CI input files?
Generally,
Did you create one for the specific Freak QC model you ran here?
yes, an input file was generated.
And did you give that to the oil and gas division?
No,
Why not?
the DMR staff did not request it directly.
Did you submit that to the EPA's portal?
What EPA portal are you referring to?
Did you file it with the EPA?
No.
Did you have some kind of an input file that was created for the other two models?
The other 2 models being the geochemical model for GEM and the geologic model.
Correct.
Those models use multiple sources of input data, so it's not a specific input file.
It's a data deck.
You could define it as a data deck.
Do you have a data package that contains all of the input files in one zip file or something similar that can then be used as a load file with the software programs?
Yes, the Patrol project itself can be saved as a file. One thing to note about that, while all the data is publicly available, that Patrol file as is now does contain some digitized well logs that were purchased from a data broker and are deemed confidential under a license agreement. So that would have to be, those specific digitized logs would have to be stripped from that patrol project.
Or simply paid for by someone else to get a license? Why do you say they would have to be stripped? For what purpose would you strip them from the package?
They're governed by a specific license agreement, so I don't have those terms available now. But there are potential ways that someone else could purchase those digitized logs for those specific wells.
And if they had a license, you could give your copy to them.
Again, I'm not sure the specific license terms for the logs in question.
Are you aware of the GEM model having a single file called with a file extension .dat that you can use to run a model on the program?
Correct.
Do you have one of those .dat files that would allow us to run the model you ran in that program?
For the CO2 simulations or the geochemical simulations?
CO2 simulations?
Yes, I believe that was provided to the commission already.
And that could just be taken and loaded into the GEM program to run the model that you ran?
That's my understanding, yes.
Any idea why Summit won't provide that to the interveners?
I believe it was already provided to the DMR, so
Any
it's
idea?
publicly available.
Any idea why the DMR would refuse to provide that to the interveners?
I can't speak to that.
Did EERC, to your knowledge, tell the DMR not to provide those files to the interveners?
Not the specific files we provided to DMR, no.
Did the EERC tell the DMR not to provide anything to the interveners?
No.
Okay. Did the EERC tell the DMR not to disclose any information that it was providing to the DMR?
No.
And there is a .dat file that can be used to run that GEM model for the CO2 dispersion that was provided to the DMR. That's your testimony?
That is my understanding, yes.
Okay. I'm going to have you turn to Exhibit 1A, which was the copy of the application we were using.
What page?
Can I have you turn to page 3-15?
I'm there.
have you just review the first full paragraph, I think, but it starts the simulation model permeability.
I've reviewed it.
Can you explain what you did when you say that the simulation model permeability was tuned globally by applying a permeability multiplier to match the reservoir properties estimated from the well testing data on the Milton Flemmer?
Yep. So the injection test from the Milton Flemmer 1 well resulted in an estimation of permeability for the Broom Creek Formation. So that permeability was significantly higher than the permeability determined through well log interpretation core analysis. So based on those results, a 2.5 X multiplier was applied to the permeability of the model globally.
And is 2.5 essentially the delta between what you had in your model and what you saw in the Milton Flemmer? Or does that represent the delta?
Yes. I believe the injection well data suggested slightly higher. We thought 2.5 was reasonable.
Does that affect your ultimate injection pressure limit?
Permeability is a factor that could impact predicted pressure, yes.
Would you describe the permeability in these storage facilities in the Broom Creek as heterogeneous or homogeneous?
Could you repeat the question?
Would you describe the permeability in these storage facilities in the Broom Creek as heterogeneous or homogeneous? Can't say
Yeah,
that
I
word.
got it wrong too.
Yeah.
They're heterogeneous.
Did you consider looking for a heterogeneous cause rather than applying a multiplier across the entire reservoir?
So the model already represented a heterogeneous distribution of permeability as distributed by the well log controls, the acoustic beats from seismic data, as well as the variograms used to distribute properties. So applying the 2.5 multiplier would increase, would increase the permeability for the full range of permeabilities. And so a single multiplier was applied as we felt, that test covers a large area as determined by the radius of investigation. And so the response of the reservoir and the determined permeability we felt is representative of the response that we're going to encounter during operations.
But even taking all that, it's possible that what you saw there was simply the result of heterogeneous permeability, and it didn't require an adjustment to the model at all, right?
That's a possibility. There have also been previous studies that have published results from injection tests that have also seen similarly higher permeability as determined by injection tests. So in our technical opinion and experience with the Broom Creek Formation, we felt 2.5 was adequate to apply.
Those other studies that did the injection tests, were those done in oil fields?
No, the other study I'm referring to is the injection test published in the Tundra SGS storage facility permits.
Did you try running the adjustment on models for each of the facilities individually versus across the entire reservoir?
No, the way we set up the model, we didn't have an indicator that would allow us to multiply permeabilities for individual regions.
The simulation model permeability that you had to begin with, was that based on the core logs?
It was based on evaluation of several well logs, site-specific core analysis, as well as regional core data. It is also informed from rock properties derived from inversion of the 3D seismic data.
And you changed all that based on one injection well test?
Yes.
Can I have you go to page 3.7 and figure 3.4?
I'm there.
Can you describe what we're looking at in this figure 3.4?
So this is an aerial view for one layer of the simulation model showing the permeability within the Broom Creek.
And can you explain the units being used in the legend with the various colors on the right and the numbers indicating which color is which number?
Yep, so permeability is being displayed here in millidarcies.
Are these pre or post application of multiplier?
Post-application.
I'm sorry, you said post-application?
Yep, so the 2.5 permeability multiplier is already applied, and then it's hard to view at this scale, but, so the top there we're looking at is 5,000 millidarcies. That's a decimal place.
Does that map look like a reasonable range and distribution of millidarcies?
Yes, so one thing that should be noted about the Broom Creek, and one thing that supports the use of applying a permeability multiplier, is the fact that the Broom Creek contains several unconsolidated sands. So these are poorly cemented sands with extremely high porosity and permeability. Because of the unconsolidated nature of the sands, we're unable to perform core analysis in them. And so the geologic model that's based on the well log data, the core analysis, and the seismic, it's typically under predicts the permeability because we aren't able to capture data from these unconsolidated sands. So that's one of the reasons that we believe applying the 2.5 permeability multiplier is reasonable in this case.
What was the max perm you observed in the cores?
So on page 2-24, table 2-6 has the range of permeabilities from core analysis. So permeability for the higher range is 2,700 millidarcies.
Sorry, I'm just not finding it. Did you say 2,700?
Yep. So
Oh, I see. Got it. So your model has ten to 20% at what appears to be 5,000 millidarcies. Does that seem reasonable?
given the unconsolidated nature of the Broom Creek, yes. One thing to be noted, I gave you the max range for the TB Langane permit. The other permits have slightly different data sets, some of which are higher from the core data for those specific stratigraphic test wells.
Higher perm?
Higher permeability. So if I can point you to exhibit the Fisher storage facility permit, similar on page 2-4, table 2-6. The maximum permeability from the core analysis for the Archie Erickson well is over 3,700 millidarcies.
When you say there's 2.5 multiplier, are you literally saying that you're increasing the perm across the entire reservoir by 2.5 times
Correct.
based on one injection test?
Correct. So again, on our years of experience studying the Broom Creek in multiple forms with core log analysis, well log analysis, core analysis, well log analysis, seismic interpretation, we believe that's reasonable. One thing that should be noted, we felt confident in using that value from this test. We will be using actual operational data to validate our model every 5 years as part of the reevaluation.
Does an overall increase in the modeled permeability across the reservoir allow you in the end to inject at higher pressures, thus resulting in the ability to inject more CO2 into the ground?
So the pressure you can inject at is constrained by 90% of the fracture pressure gradient. So you can't inject higher than that. If you had higher permeability, you would be able, you'd likely be able to inject higher volumes of CO2 before reaching that.
Thank you. Can I have you go to page 2-18 and figure, let's see. Sorry, I mean 219.
I'm there.
Okay. You have an ISOPAC map indicated on the prior page, and the well log of the formation. Other than this data, did you do any kind of research or study of the depositional environments for the formation?
Yes.
And what did you do?
So the ERC has studied the Broom Creek way back into the early 2000s. So we produced a formation outline on the Broom Creek regarding the depositional environment. The gold standard published study on that is a thesis by author named Rigg that details the depositional environment. ERC has been a part of projects that have drilled and collected core from numerous wells, Broom Creek core, and our evaluation of those core data, as well as the 3D seismic, confirmed Rigg's interpretation of the depositional environment.
Was Riggs looking at certain rock types?
Offhand, I can recall, his thesis focused on the depositional environment, and he also looked at type logs. Through those means, yes, he would have looked at rock types.
Aeolian sand dunes and interbedded marine and lacustrine limestones. Are those part of the depositional environment in the Broom Creek?
Are you referring to a specific paragraph or page from the formation? Or from the permit?
No, I'm asking if those are if those are rock types in the depositional environment studied by RIG.
I don't believe that there is limestone within the Broom Creek. I know he describes it aeolian dunes as well as interbedded carbonates, which consist mostly of dolostone as well as anhydrite.
Did you put a description of the depositional environment into the application?
Yes, it can be found on page 2-16. In the second sentence under at the text at the top, we talk about how the formation comprises of interbedded aeolian nearshore marine sandstone and dolostone layers with minor amounts of siltstones and anhydrites.
How did your analysis of the depositional environment affect your analysis of the variability of the permeability across the reservoir?
So I'll speak to the interpreted depositional environment, which is can be prevalently seen on the 3D seismic. With attribute analysis, from the 3D seismic, you can actually see dune forms. You can also see indication of interbedded carbonates and anhydrites in that. Through evaluation of the 3D seismic as well as correlation to well logs in the area analysis of that core, we have an understanding of the lateral distribution of the different lithologies within the Broom Creek, particularly, as I mentioned, those unconsolidated sands. The Broom Creek sands come in several different forms. We have those very unconsolidated sands. We also have high angle cross-bedded sandstones and things like that. So all those data sets gave us a better understanding of the heterogeneity in the reservoir, the depositional environment, how those different reservoir lithologies, particularly the sands, were distributed across the area, and what was reasonable and prudent in terms of applying for rock and petrophysic properties as well as the multiplier.
Are you familiar with the Broom Creek Formation in Wyoming?
I am not.
Okay. Are you familiar with how wind direction can influence deposition and produce sand dunes elongated in one direction?
Yes, I am.
And have you seen that phenomenon in the Broom Creek in North Dakota?
Yes, we have, as inferred, we can see that orientation in the 3D seismic data. And that orientation was accounted for with using the acoustic impedance derived from the seismic data for varigrams, which are used to distribute properties in the model.
How useful would your model be if you did not account for the deposition that we just discussed?
Define useful.
Would it have had utility to create the application for Summit for this proceeding?
Yes, so there are multiple ways to create geologic models. The EPA has a guidance document out there where they suggest modeling best practices. Some modeling best practices also include recommendations for simplified models that might just include well log data. So even simple models can have utilities to define storage or define vertical and horizontal boundaries. Uncertainties with those different types of models need to be accounted for when determining appropriate buffers and things of that nature.
Can I have you turn back to page 3-7 and specifically to figure 3-4?
I'm there.
Would you expect a map showing the range of permeability of the formation to reflect the deposition of the elongated sand dunes in the Broom Creek that we just discussed?
Yes, so one comment to make about that is some of these dunes are reworked. So while we can see elongated dunes, if you're looking at a particular slice, there might be difference in cementation of the sands and things like that. As being part of the team that interpreted the 3D seismic, I can tell you that the elongated dunes were oriented northeast to the southwest. And based on that orientation, to my trained eye, I can see that reflected here on figure 3-4.
But only because you had access to that seismic data and the 3D modeling that was done with it.
Correct.
How would we replicate the permeability distribution without the 3D seismic and the attribute analysis?
So if you turn to page 3-2, section 3.2-3 talks about the varigrams derived from the 3D seismic data. These varigrams are what were used to distribute properties. So the only difference in a model made without using the acoustic impedance derived from the seismic is that you wouldn't have that as a control point.
What would you do without the control point?
You would still have the log data and the varigrams to distribute properties.
In 3.2.3.2, it states seismic data were resampled to the geologic model grid. Can you explain what that means?
Yes, the seismic data were sampled at intervals related to the bin spacing, which I believe were on the order of 80 to 120 feet in this case. We have a data point from each one of those bins. And so the seismic data from those bins had to be upscaled to the model grid cell size.
And if we use the variograms, we wouldn't be able to double check your interpretations of the 3D seismic, right?
Correct.
Can I have you go to page 3-4? My electronic copy at least is marked a little weird, but
I'm there.
let me start by having you just describe what we're looking at here.
On page 3-4, we're looking at figure 3-1. Is that what you're looking at, correct?
Yes.
So this is a west-east cross-section of the geologic model, showing the Phi E property from the model that was used to distribute permeability through the model.
Are you able to look at this picture and find something that you would interpret to be undulating sand dunes?
So the high porosity zones in yellow and red represent those reservoir sands. The dunes here in the Broom Creek, it's a dune complex where there's deposition of sediments and formation of the dunes. When sea level rose, there is reworking of the dunes when sea level fell. There's again deposition of sediments, reworking of the sands to form dune complexes. So it's a stacked dune complex. Interpretation from a cross-section alone makes it difficult to interpret the dune complex. That's why a planar view would be required to interpret dune complexes with more certainty.
Is there anything you see on figure 3-1 that would be an indication to you of those types of undulating sand dunes?
Yes, again, based on my involvement and experience with interpretation of the larger data set, my trained eye can pick out the dune forms for the stacked dune complexes.
Based on the knowledge and information you have from reviewing the seismic data?
Correct.
What were the actual test results from the injection well that you used to make the adjustment to the model on the permeability?
The results from the injection tests were calculated permeability.
Calculated from what data derived from the injection test?
I'll defer that question to a later witness.
Do you know where in the application it's referenced?
Outside of the paragraph you previously had me review about the 2.5x multiplier, I do not believe that test is discussed in terms of interpretation.
apologize, I needed to find my place here, but back on 3-15, that paragraph I referred to earlier. It says the permeability multiplier was calculated based on the area of study during the injectivity test, the radius of investigation, and the permeability thickness transmissibility values from the pressure transient analysis. Were you involved in determining or assessing the area of study during the injectivity test?
I was not, but we have a witness coming up that was involved with this testing.
And were you involved in determining the radius of investigation?
I was not involved in interpretation of the well test results.
Okay, and I don't know what this means, so I don't know if it's that, but were you involved in permeability thickness transmissibility values from the pressure transient analysis?
No.
Okay. Were you involved in deciding on whether or not the global multiplier should be the number 2.5?
Yes.
Okay. What data did you review in order to assess what that number should be, in your opinion?
Results of the well test were presented to me. I've also been involved or aware of previous studies with similar injection tests as previously discussed, as well as knowledge again of the Broom Creek and the other data sets that support use of a permeability multiplier.
In the other studies you reference is just the one well and Project Tundra when that was done?
Correct.
And when you say you were given the results of the injection well test, is that, I don't know if I got that right, is that right?
I was presented the results by subject matter experts.
Okay. And generally speaking, what did they present to you as the results?
What's listed in the paragraphs, their interpretation from the injection tests of those different parameters, including radius of investigation, permeability thickness, and such.
And how did you use those then to determine a multiplier of 2.5?
So the permeability, the summary of those results was the permeability was higher on the order of 2.7 or so times higher than permeability from some of the laboratory analysis.
Are you aware of what a calculated KH was?
I don't recall at this time.
Were you given that number at some point?
I don't recall at this time. I know we've looked at KH in terms of the model. I was given the permeability thickness.
And what was that?
I don't recall at this time.
Do you have the time height?
I don't have the test results in front of me.
Okay, but were you given that information?
I don't recall specifically, but I believe that information is in the well testing report that's on the NDIC website.
All of the information including the calculated KH is all on the NDIC website?
I would have to review it. Can't speak to that level of specifics.
And can you explain, you've said that it was, the difference in the perm was calculated at 2.7 and you went with 2.5. Can you explain why? And actually, let me back up. The number calculated from the injection test was 2.7, right?
On the order, approximately. I don't know, recall the exact value.
Okay. And you decided to go with a multiplier of 2.5. Why use 2.5 instead of the actual value?
We felt it was a conservative assumption.
Why do you describe it with the word conservative? How is it conservative?
It's lower than the test results reflected.
Is there any reason to assume it's more likely that the perm is lower than the test result than higher?
So I don't think we have data that would indicate which is the appropriate choice to go higher or lower. We chose 2.5 based on our knowledge of the Broom Creek. We believe that was a conservative estimate to use in the model. As we discussed previously, higher permeability might result in higher volume of CO2, but also potential higher pressure. So using a more conservative, going on a lesser number, helps ensure that we're not overestimating CO2 plume size.
And are you being conservative because you're concerned about the risk of having that number be 2.7, having a delta of 2.7 between the injection test and your modeled perm?
There's not a concern with using the exact value. We wanted to be conservative in what we chose in terms of how we defined the horizontal and vertical boundaries.
But isn't the actual data the best data that you have?
Again, it's not the only data set we have.
Okay, so you're putting less weight on the data derived from the injection well test than from the projected permeability from the other data you've used.
Not less weight. We just chose to choose a conservative value.
But when you say the word conservative, why is it more conservative to go to 2.5 from 2.7 rather than going to 2.9 from 2.7?
Can you repeat the last part of the question?
Well, when you say that you were choosing 2.5 rather than 2.7 because you're being conservative, I'm asking why it's conservative to adjust down to 2.5 versus adjusting up to 2.9. Why is that conservative?
Again, as you mentioned, this is a single test. And it was this permeability multiplier applied to the model, which the model was used to define the storage facility boundaries. in the development of the project, we felt it was prudent not to over-predict the plume size. If the reservoir doesn't act like that, then we've permitted an area much larger than would be needed.
Okay, I think this is a good place to stop. We will resume tomorrow morning at 9 a.m. So that will, I guess, conclude our hearings for the day. Go off the record at 6:30 p.m.